Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
No, I'm not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern, or
I am not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt.
I read him.
You just sit quietly.
Thank you.
I read him the report so that we will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
All right, welcome back to the Court of Public Opinion. Happy Friday. It is Friday all day today. That's the good news. Welcome, welcome. It's good to be back here with you this morning with wonderfully working internet as well. Good morning, good morning. We're going to sing happy birthday to people who need it, because there are some people who need it, trust me. And then we'll get things kicked off as we have a little bit of a funny day lined up, at least for a little bit before we get serious and start watching court. Pants are a lot today. They are. That's why it's No Pants Friday. It's perfectly acceptable for you to be pantsless while watching chat today. Why is this not working? Thomas, I turned it on and then it didn't turn on. Let's see. Let's try that again. Still no. Now it's working. Airbnb's Wi-Fi. Fixed it. All right, we're working now. Great podcast last night, by the way. Thank you, Thomas, and all of you who were there. If you didn't watch it, you have to watch it. It's a mandatory watch. So you have to do some replay action over the weekend at some point. We will talk about something that's not relevant in just a minute. We are going to celebrate some birthdays in just a second. Hopefully you've got your birthday submission in before we go ahead and sing and get everything started off. Let's see. Podcast was epic, says Melissa. It was pretty good. We really, really loved it. Have you seen my email with picture of custom Lego piece?
Happy birthday. You look good.
Oh, thank you, Judge Fleischer. Coming in early with the big old HBD. Let's see. Custom Lego piece. What is this? Is this like a Femtomax undulator, dump magnet, X-ray? It's like a production line. Safety shutters. Did you build this? It's like a Lego scale model of a factory production line or something, or maybe some scientific.
I saw.
That's pretty wild.
I saw a chicken fight.
It's sort of hard for me to read the words because I have old eyes and it's a new picture.
You're talking about stuff that is not relevant.
Legos, always a bold choice when demonstrating anything of scientific noteworthiness.
If they didn't, I would lose my mind.
If your audio is skipping, my audio is skipping. Test 1 2. Test 1 2. What would make the audio skip? It looks good on my end. Let me go ahead and undo a little feedback. I know this is going to be a little annoying for y'all.
In front of the Walmart.
But I'm going to turn on what I hear. Ready? Test 1 2 3. Test 1 2 3. Everything seems to be working just fine. Check. It seems to. I can hear myself just fine. This is a feed just from YouTube, so it seems to be working. Although it's doing the wisp. Is that what you're talking about? The whisp. That's the professional sound that makes. Still buffering on your end. It's all good. Audio's fine for you guys. I will give you a little secret. If it's only happening for a few of you, it's not on my end. I'm sorry. I wish I could fix it. I wish it was something I could just push a button and make it better. But refresh your page. That's all I can say. Refresh your page. I'm taking this up with my YouTube representative to say, what did you guys do that has broken everything? Because it's been terrible. Like we need a different platform type terrible. We have the buffer in with the birthday wishes. If you look here, we've got Melissa Ann, Angela, Tanya, the three of them all celebrating. Angela, you know I can't pronounce your last name. Djordjevic. I'm going to say Djordjevic, if that's, and please forgive me, because you know I can't pronounce things. Show us your shirt. It's a Red Solo Cup shirt. Magellan Outdoors. Thank you, by the way. I think this was from Melissa. Chat again. We're back. We're going to sing Happy Birthday here. By we, I mean all of us. So please stand up, take a deep breath, stretch your shoulders back, sort of roll them back, pop your neck if you need to. Deep breath, project your voice to the back of the room, blend your voice with your neighbors. Warm up with me if you will. La 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 la. We're going to sing Happy Birthday to Melissa, Angela, and Tanya. Happy birthday to you. Happy birthday to you. Happy birthday, Melissa. Angela Djordjevic and Tanya. Happy birthday to you. Djordjevic. Angela Djordjevic. Angela, I'm going to need you to change your name. I know it's a big ask, but I'm going to need you to change your name to something like Smith. If you could just hurry and get that done so I can pronounce it right, I would appreciate it. I apologize. There's some words my mouth just cannot say, and your last name is one of them. So, thank you so much. Have a happy birthday. Please help yourself to pancakes. Denny's, Waffle House, IHOP, Village Inn, Tammy's house. If she's cooking pancakes this morning, I'm sure she'll have some for you. Anyway, we realize there are a million places you could be, a million people could be. Can we start over again? I realize there are a million places you could be and a million people you could have been with, but you chose to be here with us. Thank you very much. The privilege and pleasure is all ours. Hopefully we can turn that in some small way back to you and make your day a little more specialer. There's like a fuzz thing on my mic. It's tickling my face. That's all, folks. That's all, folks. Yes, I messed that up. Happy birthday. Many happy returns to all of y'all. Love when a birthday falls on, or celebration falls on a Friday, because you get to celebrate all weekend long. So for you three, that happens today. Pretty sure I just heard like a police siren right outside my house, but it was like one of those woohoo when they just try to get you to pull over. They're not really chasing you. So hopefully it's not that person's birthday. Okay, I think we've got a drum solo coming up. Yep, here we go. I missed it last time. I'm not going to miss it today. Beautiful. All right. I have to say this, and Weather Watch, this isn't just for your benefit, but there is some crazy weather going on right now. It seems like we've been able to say that pretty much any day of the week for the last couple of years, but there is some crazy weather happening, and we want to bring you the best of all of what we can to keep you informed about what's happening. Normally, we turn to Thomas. Thomas, being our resident weather expert, able to just fill us in and give us the lowdown. But sometimes you find a weather prognosticator. Is that the right word? A weather forecaster in the oddest place. And this morning, we're heading to no other place other than Minecraft Court to get the latest and greatest on whatever is happening with the weather right now. So, ma'am, court reporter, are you ready? Yes? Okay, go ahead. Let us know what's happening.
Watch yourself, because it's a big pile of slush and you might fall on your ass. I go, no, you take the next step. It's like kind of crunchy and poofy, but there's something yucky in the middle, and then it's all slushy on the bottom.
Okay, there we go. So there's our weather report for today. Watch yourself, because you might, tea kettle it. So thank you for that report. I just caught that this morning. It was apparently Minecraft Court has some bad weather. Thomas poured milk all over my leftover spaghetti, and it was great. That is just, I'm never going to live this down. One day you guys are going to try popcorn and milk, and you'd be like, why didn't you tell me about this earlier? And it's that good. It consistency-wise, you have to get over the same hurdle you have to get over the first time you try oysters, which for me, I actually have not gotten over because I've never tried oysters. But the idea of slurping down the innards of an oyster is no worse than the idea of popcorn and milk. But I hear once you do it, it's amazing. So just, yeah, there's like zero chance that Weather Watch did spaghetti and milk for breakfast. All right, so I guess we should probably go back to Minecraft Court a little bit. Could it be chocolate milk over popcorn? I haven't tried that one, but I'll give you a pass if you want to give it a try. Let's see. Yeah, if you missed the milk references, that was the podcast last night, and I apologize. Apparently, my good taste is not shared by everyone. Let's put it that way. It is Friday. Our court case yesterday ended with a verdict, a surprise verdict, in that the judge cut off the live stream before the sentencing, probably because the defendant was exhibiting signs that maybe that mental evaluation was needed. So the good news is, as he faces his up to 14-day incarceration for his reckless driving and reckless endangerment of his 2-year-old child in the car, he goes into jail with a clean conscience, with a conscience devoid of wrong to God or man. He has repented of his sins, he said, and he's ready to move on and be a law-abiding citizen going forward. It was a great speech. It was a great speech, but at that point the judge cut off the live stream and we never found out what the verdict was. So it was all good. All right. Jamie L., did anyone find out the kid's sentence from yesterday? I looked, I could not find it. I was on the Thurston County page looking at the latest and greatest from what's happening up there, and nada. The daily listing of court cases didn't even show it. The upcoming cases, the past court cases, it was nothing in courtroom 4 was showing up, other than the fact that today there is another trial in courtroom 4, and it's a bench trial. It starts at 9 a.m. Washington time, which we might pop in on, just see what's happening. But let's see. Let's see where else. We were going to go to Minecraft Court. What was that? Is that this one? There's a court. This one sounds terrible. Let me see if we can fix that.
To me.
Yes, sir.
And you've been coming here for what, 4 or 5 years now?
Too long.
Okay.
Yes, Your Honor.
So what have you done about that?
When I'm on the outside, I do. Mental health is very important to me.
Okay,
I go to Signature Health in Willoughby on my own free will. I'm not court ordered to do this.
Okay, we're going to stop for just a second. Stop. We're going to back up. This gentleman, I was trying to get to this point, has a little open conversation with his lawyer. Let's see if I can catch this part.
Try to give you some long drawn out.
Hang on. Okay, it's right after the buzz. When the buzz is done, we start.
Oh, okay. It's like at the same time, Jim, I do need some help.
He does.
Like,
I know.
It's like at the same time, I have an alcohol and drug problem, and it seems like when I do relapse, it gets out of control. It's like I seem like prison's not going to always be the
it's out of control now.
Going to help
Not
me,
just...
you know. But if you want to read this real quick, I put a lot of time and effort into these 2 letters, and I put a lot of time and effort. And I probably put weeks worth of effort into writing these 2 letters.
A week's worth of effort condensed down into one brief writing session. I don't know how long. Are they really written
Very
well?
well wrote.
Oh, they're
Very well wrote.
Very well wrote.
Well, what do you want to ask for, Ricky? Do you want to ask for the 18 months? Or
If I go to treatment, I'll be on probation.
Correct.
But I feel like it'd be more of an incentive to do right. At the same time, I need that extra push in the right direction.
Okay.
I'm not lying, Jim. I really do need the extra push in the right direction. I feel like failing probation would probably put me on the right track where I need to be.
Okay.
But if not, worst comes to worst, she's recommending 18 months.
Well, that's a joint recommendation.
Yeah, yes, sir.
That's if we recommend the same thing.
Yes, sir.
If we ask for 18 months, she will ask for 18 months. But if we want to ask for probation, then she is no longer restricted to asking for 18 months.
This is an open conversation in a courtroom.
For anything. Now,
all rise. You seated. Ms. Wood.
Thank you, Your Honor. We're present in case State of Ohio versus Ricky Shean, case number 24 CR 327. The defendant is present today in court represented by attorney Jim Matthews. We were previously in court October 24th where the defendant pled guilty to an amended count 1, assault, a felony of the 4th degree, as well as counts number count number 4, OBI, a felony of the 4th degree, as well as count 6, stopping after an accident, a misdemeanor of the 1st degree. This case was then referred for an updated pre-sentence report and victim impact statement, and we're set for sentencing here today.
Let me pause for a second. Privileged communications happen in private, and this was with other people right there listening. It becomes not privileged. It becomes not privileged when it's said in public with everything right there. People full on able to hear, it becomes not privileged. And I realized it was a conversation that could have been held in private conversation, but it was not because of how they held it.
Thank you.
Mr. Matthews.
thank you, Your Honor. At the time of the change of plea, we did indicate to the court that there would be a joint recommendation between the parties for 18 months in prison, credit for any time served. Mr. Shean has recently been speaking to Aaron Mayer at my office and does wish to request that the court place him on community control and get him some much needed help for his issues with drugs and alcohol. There are a couple of options that Aaron had presented that Lake Geauga would be willing to consider him depending on the outcome of today's hearing, and also that Alpha House in the city of Oberlin would be willing to consider accepting him. We would hope, though, that if the court does not find Mr. Shean amenable to community control, that the court consider a sentence of no more than 18 months in prison, Your Honor. Thank you.
That's a surprise to the prosecution. Whoa. Oh my goodness. The microphones are not for clearing one's throat. I want the reporter to give an updated weather report right now.
All right, Mr. Shean, what do you want to tell me?
Your Honor, good morning, Your Honor.
Morning. Good afternoon.
Good afternoon, Your Honor.
This was yesterday.
Your Honor, I wrote this letter. I put a lot of time and effort into this, a lot of feeling and emotions, too.
It's a different letter than the one I gave you.
Good.
Your Honorable Judge, I come to you today claiming full responsibility for my actions the night of my arrest and all the past offenses. I understand in the past I have tried to manipulate the truth and even tried to, but unsuccessfully lie to you. I have done a lot of growing up since then. I know now that I don't have all the answers, and my best decision making has gotten me right in front of you, back in front of you today. Your Honor, I am not here to try to give you some long drawn out excuse for what I have done. I'm here to apologize to you, the community, and most of all, the officers from that night. I am learning that honesty is the biggest attribute that I can have to live by to change my life around. The biggest truth that I have came to is if I don't find some person, place, or thing to teach me about how to fight my drug addiction and alcoholism, I am surely going to die from my disease. That night, I admit and take full responsibility for mixing my alcohol with prescription drugs and other illegal drugs and driving very reckless and endangering the lives of others and myself. I am ashamed of my actions of that night. I am embarrassed for treating public officials the way I did, and did now realizing that they were just protecting the community and myself by doing their jobs to the fullest of their abilities. For that, I owe them more than just merely an apology. I also owe the victims and the city of Willoughby and Eastlake and you the most sincere apology from the bottom of my heart for the harm I caused everyone involved. I cannot keep living like this way, Your Honor. I am willing to go to any lengths to obtain sobriety in my life, but I cannot do that on my own, Your Honor. And that is a fact. We both can agree upon that. I am pleading and begging the courts to save my life and give me a chance to gain some real sobriety. I am willing to do any programs or jump through any hoops or obstacles that you deem necessary to reach a chance at a long-term sobriety. I know now, without your help, Your Honor, I will surely die from my disease, without a doubt.
Where are you living now? Where at?
At 72 Sharon.
And who lives there?
I was staying there by myself.
Who owns that place?
My father.
Where do your parents live?
799.
Okay. What's your relationship with them lately?
Oh, great. Your Honor, my family's very supportive of me just doing good. They just want honor. Your Honor, they're just sick of the nonsense. They're just sick of this cycle. It's just like, Your Honor, they just want me to put a stop to this. I'm getting too old for this. I'm 30 years old. I've been doing this since I was a child. It's just.
Why is that?
Your Honor, I have an alcohol and drug problem. I'm being honest with you. It's just.
Well, I mean that's abundantly apparent to me.
Yes,
While
sir.
it hasn't been to you for a long time, it is to me.
Yes, sir.
And you've been coming here for what, 4 or 5 years now?
Too long.
Okay.
Yes, Your Honor.
So what have you done about that?
Too long is right.
When I'm on the outside, I do. Mental health is very important to me. I go to Signature Health in Willoughby on my own free will. I'm not court ordered to do this. I go to Signature Health in Willoughby willingly. I'm on the MAP program. I start IOP. I even go to AA meetings. I probably do about 2 or 3 a week, but I try. If I can, I'll go to 5, but that's if I can get a ride. It's more. I like the atmosphere.
What medication did they have you on?
Where, in the jail?
At Signature.
Signature, they had me on Boost bars 3 times a day. They had me on Seroquel 3 times a day, Remron at night, Effexor, and Suboxone.
Okay.
And Suboxone's, of course, I was in the MAP program, Your Honor.
How long have you been on Suboxone?
On and off for the past 5 some years.
What's the plan to get off Suboxone? Is there a plan to get off?
Yes, Your Honor. Of course, I would wean myself off that, and that's the goal. It would be, say, if I was taking a whole dose a day, I would work my way off of that. I would be half the dose and then slowly work off of that and work.
Is that what the doctors are telling you?
Mm-hmm. They told me that usually instead of, it's an 8 milligram strip, so you would work your way down to like 4, half of that dose for a week or 2, and then after that, it's down to 2 milligrams, and then it's cold turkey after that. And you're completely off that.
So somewhere in this PSR, I was reading that you claim that you were sober for 10 months?
Yes, Your Honor.
Is that right?
Yes, Your Honor.
And then you went off when you went out this night in Willoughby?
Yes.
Is that right?
Yes, Your Honor.
Okay, so what did you do to stay sober for 10 months?
I was going to Signature Health, and I was going to AA on my own free will, Your Honor. And really, AA was really keeping me sober. It's just, I figured out it's really the people that are around me. It's like I had sober circle around me. I had people I could call at any time if I felt like I wanted to drink or use, and that was helping me a lot. It just, Your Honor, it just took a lot that day. That day was a terrible day. It took a fight with the family and the argument.
What was that fight about?
It was some dumb stuff. It was about, it was so dumb. It was about getting a job, at moving, stuff like that. It was about life stuff. But then after I left that, I de-escalated the situation and left the house, because that's how I deal with stuff now, Your Honor. If I get in an argument with somebody, the best way my coping mechanism is I leave, because that's the best, that's how I deal with stuff nowadays, and that's the best way to resolve everything. So I left, and I had called my ex-girlfriend, and of course, I tell her everything, and now we get into an argument over something dumb. It was so dumb. I just ended up leaving, and I called my friend Josh that lives out here, and I was like, I just like, what's the point of staying? I made it 10 months, Your Honor. I made it 10 months. I was doing so good. Everybody was so proud of me, Your Honor. I was proud of myself. I'm so mad at myself because I feel like I gave that up. I feel like I gave it up, but everybody in sobriety is telling me that's nothing. That's okay, Ricky. It happens. There's nothing to get back on the horse, and you could gain that back. I mean, I haven't had almost a year sober in a long time, and that felt really good. And
when you were going to you said you were going to AA during this period?
Yes, sir.
Did you have a sponsor?
No, Your Honor.
Why not?
Because I was just getting rides to certain places, but I was working on getting a sponsor, but I didn't get a sponsor yet, Your Honor. But I was staying sober, so I was doing very well. But the sponsor was the next step, Your Honor.
At one point in your past, you were working for your parents' business, right?
Yes, Your Honor.
And what business was that?
They owned a business. It's a convenience store, a gas station.
Where's that?
156th and Lake. And
why did you stop working for them?
That's the one spot they actually they just sold it and they got a place closer. It's a Sunoco gas station now. They own a Sunoco on 250th.
And Euclid Avenue?
Yes, Your Honor. It's by the high rises. And I work there whenever. I get hours whenever I want. So
what was the argument about you getting a job?
Because they have so many employees. They don't always need me there. But I show up as much as I can.
Okay.
You get what I mean?
What is it you want to do in the long run?
Your Honor, I went to downtown. When I went to Menor High School, I went to Willoughby Tech, if you know what that is.
Yeah.
I did 2 years in a shop. I'm an auto mechanic. I like working on cars. It's one of my things. Your Honor, I'm not a dumb individual. I just do dumb things sometimes. And I apologize for that. And it's not me. It's the alcohol and drugs. But I was working on cars. I love working on cars. I could do anything on a car. Besides that, Your Honor, I started teaching myself other trades. I started teaching myself how to work on computers. I can build computers from scratch. You can give me all the parts. I can build a computer. I probably built about 50 computers in my life. I started teaching myself how to work on. Started teaching myself HVAC on a house, even on a commercial building. I taught myself this.
Whoa.
It's not very hard. I actually taught myself this stuff. I installed a commercial AC unit before on top of a building and installed it, put the conduit, ran the conduit.
Where at?
It was on that lakeshore at the convenience store.
So if you can do all this stuff, why don't you do all this stuff and quit hawking candy bars and gas?
I just need, yes, Your Honor. Great point. No, 100%. I thought about, what is that, Auburn Career Tech? It's like you can pick up a trade in 4 to 5, 6 months. That was my goal. I want to go to a trade school where I can pick up a trade in 6 months. Because a man's not trying to hire you nowadays if you're not certified in nothing. If you're not certified in nothing, a man doesn't really want to hire you. It's like a man doesn't really want you working on his car unless you're certified. You know what you're doing.
I mean, that makes sense, doesn't it?
Yes, it does, Your Honor.
Okay, so let's see.
Yeah, it worries me that he did HVAC without license. There's some stuff you need a license to
And I also started
purchase for
teaching
HVAC.
myself how to work on, I started doing heating furnaces, the hot water tanks, soldering hot water tanks, all the plumbing in the house, all the electrical, all the breaker boxes, all the, the electrical stuff and all the wiring and stuff.
Where have you done that?
I did it in a couple of houses. I was helping my friend refurbish houses. So it's off the record, you want to say, because I'm not certified. So I was doing it. He was paying me under the table, but I was doing stuff like that in a house. I was fixing houses, refurbishing houses with one of my friends that was actually buying houses and flipping them.
Please give us the addresses so we can repair them.
You've got, what do you got?
I like that he's a go-getter, but
I never knew life could be, it just started looking so good. I never knew the good part could be so good. When I was 10 months sober, I started actually seeing that, Your Honor. I never seen that part. I've always seen the bad part. I never seen the good part, and I finally started seeing the good part, and it started opening my eyes. I don't want to live like that no more. I really don't.
I think
it's not a way
a point
of
where
life.
he's
my
ready to make a
family didn't
change.
raise me like that. My family doesn't want me live like that, period. They're great people. They're good people,
He does need help, and I don't think at this point probation is the best thing for him. I think there's definitely some genuine
Okay, so
stuff
you
there.
were first year in 17, so it's 7 years ago.
2017.
You were on intervention in October of 17. That didn't end well.
Yeah, I was just a
Ended up
child.
in prison for about 14 months, 13 months. Let's see. And you got a bunch of stuff right off the bat. Bunch of stuff in Painesville Municipal Court. Let's see. And then about 3 years ago, two different OVIs, plus vandalism and obstruction.
Yes, Your Honor.
Got you about 18 months in prison.
Yes, it did, Your Honor.
Get out in May of 23, May 11th. And you got disorderly May 22nd, criminal trespass June 20th, June 21, criminal trespass July 3rd, resisting. September 14th, domestic violence. February 26th, disorderly conduct. And this stuff in March. So you're creating quite a footprint.
Yes, I am, Your Honor.
At 30, right?
Yes, Your Honor.
Okay.
Had a lot of growing up to do. I really do.
Now, when you came here, let's see when this was. You've been in jail 194 days. Is that right, Kim?
That's correct, Your Honor.
Okay. So you were here on April 16th for a pretrial. And there was a motion to modify bond.
Trying to get out.
For you to get out, and I denied it. Do you remember that?
Yes, Your Honor, and I apologize for the way I acted that day.
Why were you acting like that?
It's just, my dad wasn't doing so good. He's still not doing so good. It's his third, he just had open heart surgery. He's recovering a year and a half now. He's having a lot of chest pains. He's not doing so good. It's his third heart attack. It's just, I don't, my worst fear, I don't want my worst fear to come true, Your Honor. I don't want to be locked up and something happens to my dad and I'm not there. It would hurt me so much. And that's why I acted the way I did. I acted out of anger because that's all. I just wanted to be there with my dad. And I'm sorry the way I acted. That was childish, and I apologize for the way I acted that day.
He's saying the right things right now, but I think letting him out.
Okay. Ms. Wood?
He needs more help.
Thank you, Your Honor. This was an incident that occurred in the city of Eastlake. The defendant operated a vehicle. He had a passenger, Josh Connors, in his car. He was driving and struck a car driven by Kyle Kia. He caused some damage to Kyle's vehicle. He continued driving. His vehicle turned left and got stuck in the grass area of a business, where then the defendant proceeded to leave the scene of the area. Several bystanders saw what had happened and pointed the officers into the direction of the defendant, who left on foot. The defendant physically fought with the officers on the side of the road. They fought with him to get him in the backseat of the cruiser, and then when they arrived at the Eastlake Police Department, he continued to fight with the officers. He caused physical harm to the officers, and then he continued to be uncooperative while he was at the Eastlake Police Department getting booked in. He caused a risk of serious physical harm to himself, to his front seat passenger, to the public, the other people driving on the road that night. There has been a rehabilitation failure. The defendant has been placed on community control. Prior to this, he violated, he was sent to prison. He has 2 prior prison numbers in his past. He's continued to pick up new criminal offenses even after he's been released from prison. The defendant stated that he has substance abuse, drug and alcohol issues, and he has refused to apply the treatment tools that he has learned by attending Signature Health and by attending AA meetings because he continued to pick up new offenses. Originally, we did have a joint recommendation for 18 months, but since the defendant no longer wishes to join in on that recommendation, the state is recommending a higher prison term than 18 months. We would defer to the court if the court does impose prison on the appropriate prison number. I'm also recommending $500 in restitution to Kyle Kia. That was the vehicle that the defendant struck because he paid $500 towards his deductible. There's also a mandatory fine on the OVI as well and a mandatory driver's license suspension.
What is the fine?
On the OVI?
Yeah.
A mandatory fine of $1,350 up to $10,500.
And the suspension is at 3 at least, or is it more than that?
It is at least 3.
3 to life?
Yes.
Okay.
3-year driving suspension? I call this Minecraft Judge, or Steve. I don't recall his name. This is Minecraft Court.
Where have you been to treatment before?
I've been to Matt Talbot in Parma, and I completed that. It was a 60-day program. Been to treatment, Your Honor, I think only a couple times. If you consider JTP, I did JTP a couple times. And then Sky Point Recovery in Akron, I think. I think it was Akron. I'm pretty sure it was Akron. Only been to recovery about 3 times, Your Honor.
So why don't you follow up with that stuff once you do it?
What was that, Your Honor?
Why don't you follow up? Why don't you figure out what you have to do based on what you learned when you were in treatment?
Yes, Your Honor. I was doing pretty good once I got out of, I got out of Sky Point Recovery. That's how I made it. That's how I made it almost a year sober. I made it 10 months sober. That was after recovery. That was, I forgot which judge. I think it was Judge Turbetz that sent me to rehab, and I went to Sky Point, Your Honor. And after I got out, I was almost a year sober. So treatment definitely did affect me, and I used the tools that I learned from rehab, and I used it in my life, and it did help me a lot, and I was doing good. It's just, I just gotta find more coping mechanisms, so when I do get in a stress situation like that, to call somebody. Instead of going out and drinking or doing drugs, I should call somebody. And that day I should have called somebody, Your Honor. I made a huge mistake, and I messed up very badly, and I apologize. And I feel very terrible about this. And I cannot stress that enough.
I think he can be successful in a treatment program, but it probably needs to be inpatient.
All right, I've reviewed the pre-sentence report, this one and the old ones, going back to 21 and 17. I've considered what Mr. Shean has had to say, what counsel has had to say. I've considered what was once a joint recommendation that is no more, so.
It's separate recommendations.
And I've considered all the provisions in 29, 29, 11, 12, and 13. I'm going to put you on community control for 5 years.
Whoa. He gets probation.
You're going to serve 230 days in jail with credit for 194. And such time as a spot is available at Alpha House, and you're going to enter into and complete the Alpha House program. The remaining days will be suspended. You're going to complete that program. successfully,
Yes, Your Honor.
and they're going to make recommendations for you after you leave, and you're going to follow those recommendations.
Yes, Your Honor.
You continue your mental health treatment
Yes, Your
that you
Honor.
currently have and follow those recommendations. You're to attend at least 4 AA meetings a week
Yes, Your Honor.
and obtain a sponsor,
Yes, Your Honor.
obtain and maintain full employment.
Yes, Your Honor.
Now, you talked about a lot of things that you could do, so figure out what you're going to do and do it. Get away from the gas station part-time business. You're to see only one doctor and one dentist and one pharmacy for medication. You're to take your medication only as is prescribed. You're going to sign releases for probation to get your records.
Yes, Your Honor.
I'm going to suspend your license, but after it's over, you're going to get a valid driver's license. You're going to pay restitution. Is it Daniel Kia?
Yes.
In the amount
Kyle
of,
Kia.
huh?
Kyle.
Kyle?
Yeah, Kyea is the last name.
Isn't that what I said, Kia? Or did I say something else?
I think you said Daniel.
What's the name, Kyle?
Kyle is the first name.
Kia, okay. Kyle Kia, in the amount of $500.
Yes, Your Honor.
And you're going to pay the cost and supervision fees. As far as the terms, Ms. Randallson, anything else?
No, Your Honor. How long will a driver's suspension be?
I'm getting there.
Oh,
I'm
okay,
getting there
sorry.
next. On the OVI, there's a $1,350 mandatory fine and a 4-year driver's license suspension. And that will be effective March 5th of '24.
Yes, Your Honor.
These are some tough conditions. It's a lot to comply with.
You understand all the terms?
Yes, I do, Your Honor.
If you violate the terms, the state will file a motion to terminate your community control. If I find you violated, what is it, 18 plus 30 potentially in prison? Ms. Wood?
Yes.
Okay, you potentially face 48 months in prison. You understand that?
Yes, I do, Your Honor.
And then after you get out, you might be on post-release control for 2 years under the parole authority with conditions. And if you violate, they could send you back to prison for up to 9 months for each violation. If it's a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months of the time left under post-release control. The items subject to forfeiture are forfeited. The remaining counts are dismissed. Anything else, Ms. Wood?
No, Your Honor.
Mr. Matthews?
No, Your Honor. Thank you.
I would say, Ricky, at this point, it's like now or never for you.
Thank you, Your Honor, for this chance. I really greatly appreciate it.
do
You have a
something
great
Do something with it. I'm not sure if the judge is convinced that he's going to be successful, but he gave him a shot, and I think it was structured pretty well. We're going to jump over to Judge Fleischer here in just a minute. Give me a second to get him pulled up.
I'm sending you now for a drug test. I want to know what, if anything, is in your system. You were to take the drug test and you're to come right back. If you fail to take the test, if you fail to come back, I will issue a warrant for your arrest. You will not get any more PR bonds. Do you understand? Okay, take his speech for me.
All right, Judge, next is page 4. Caldwell, come on up.
The judge has a full court today, and he might have a bench trial. I think that's what you guys said. There's a bench trial scheduled today for the docket.
Oh, and I'm fine, probably. Jordan Caldwell? Ms. Caldwell, you were charged with assault of a family member. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you now.
Yes, Judge. The officer is dispatched to a residence in Harris County, Texas, in response to a family disturbance. The complainant stated that she got into a verbal argument with the defendant, her daughter, because the complainant believed the defendant was not taking care of her children. At that point, the defendant picked up a baby bottle and threw it at the complainant, hitting her in the cheek, causing pain. The defendant admitted to having thrown the baby bottle.
And I'm going to find that there's probable cause to go forward with your case.
The baby bottle case.
I don't show a protective order as an issue. Do you show one? No? Okay. Ms. Caldwell, I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Candy Lachey as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works.
There's a bit of attitude.
You understand? It's not an answer, ma'am.
Yes.
How old are you, ma'am? Are you here with anyone today? Who are you here with today? I'm sending you now for a drug test. I want to know what, if anything, is in your system, ma'am. You're to come right back. If you fail to take the test, if you fail to come back, I will issue a warrant for your arrest. You will not get any more PR bonds. Do you understand? Okay, can you have her sign the note before she leaves, and then we'll send her for a test, please?
You're done with it, Your Honor?
For now.
All right, Judge, next is page 5.
A little bit of attitude there.
Duran, Aaron?
Yes. You are Aaron Durden?
Yes, sir.
Mr. Durden, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, yes. Okay. On November 14, 2024, the officer was on a traffic stop in Harris County, Texas, with emergency lights activated when he heard an engine roaring of a performance motor vehicle and observed the defendant's Lamborghini on the feeder road traveling at least double the speed of moving traffic with a posted speed limit of 45 miles per hour.
Lambo.
The officer observed the defendant's motor vehicle swerve in the feeder lanes and enter South Highway at a very high rate of speed without signaling a lane change. The officer terminated his traffic stop and attempted to catch the defendant. The officer observed the defendant's motor vehicle turning into a bar and initiated a traffic stop. The officer approached the motor vehicle and observed the odor of brakes and engine burning from aggressive driving. The officer observed the defendant to be the operator of the motor vehicle sitting behind the wheel and observed a strong odor of an alcoholic beverage and watery eyes. The defendant stated he was coming from Captain Tom's and standard field sobriety tests were started. The defendant then complained he had poor balance, and the defendant fumbled through his wallet trying to find his Texas driver's license and stalled when answering where he was coming from. The defendant was searched, and the officer found a receipt from a bar in the defendant's short pocket, and HEN eventually was conducted, finding 6 out of 6 clues. Walk and turn and one leg stand were refused. The D was read the DIC, but refused blood. A search warrant was obtained and executed.
I think there's probable cause.
Mr. Durden, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it. That is a blow and go that you put on your car to make sure that you don't have alcohol when you get into a car. If I find that you drive a car that doesn't have one, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, Judge.
I'm also ordering you not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds for you, sir.
Yes, Judge.
Understand that we send notice to DPS in Austin so that any and all officers know if you get pulled over, you're to be driving a vehicle that has an interlock. And if you drive one that doesn't, they will immediately take you to jail. So beware that the all-seeing eye knows. You understand?
Yes, Judge.
We're going to give you time to hire lawyers. So I'm going to have you go to Victoria, sign a reset. You will then get with Felicia for your bond conditions, and after that, you'll be free to go. All right?
Judge.
Okay. Please. Hi, Billy.
Lamborghini DUI.
5, Flores, come on up.
He can definitely afford a lawyer because he can sell his Lambo if he needs to. The Lambo was caught smoking, yes. That was probable cause.
Jose Antonio Guzman Flores. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The complainant and the defendant are in a dating relationship. On November 16, 2024, the officer was dispatched to a residence in reference to a disturbance. The officer made contact with the complainant, who stated she and the defendant began to argue. When she discovered the defendant gave her an STD. The argument began as verbal. The complainant wanted to leave, and the defendant grabbed the complainant's wrist and began to pull her. The defendant then grabbed the complainant's purse, which was wrapped around her waist, and then began to pull her hair. The complainant and the defendant separated when officers arrived. The defendant stated he did not put his hand on the complainant by grabbing her wrist, and pulling her because he wanted her to calm down. The officer observed an injury to the complainant matching her statement.
So you said pull the hair? Is that what you said?
He pulled her hair, yes, Your Honor.
And did you say that it hurt?
The complainant did state that she felt pain.
All right. Okay, Mr. Flores, I'm going to find that there's probable cause to go forward with the case. Do we know if she wants to have contact with him? Yay or nay?
A rip was performed. Let me see real quick.
Take your time. No rush. I don't see.
This judge requires the probable cause affidavit.
All right, so
to be
does not appear she wants contact with the defendant, Your Honor.
No
contact.
All right, so I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Robles as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? If you violate this court order, the state can and will file additional cases against you, a violation of a protective order, and it's one of the worst misdemeanor cases you can pick up. So just stay away. Don't have contact with her. If she texts you, don't reply. If she calls you from an unknown number, hang up the phone. Just don't have any contact and everything will be fine. How old are you, sir?
22.
What do you do for a living?
I'm a technician right now.
And what kind of money do you make a month?
Sorry?
How much money do you make a month?
$3,500 a month.
And who do you live with?
With my mom.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here. We'll have you sign for the order for protection. I'll have you sign a reset with Victoria. We're going to get you out of here to hire a lawyer. After that, I'll have you take a seat while we get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Okay? Well, if you can file no contact and no weapons.
Yes,
Green. Time. All right, Judge, page 8.
So we've had STD and a Lambo so far.
You said page 8?
Page 8.
Okay. Taana Green. Good morning. Ms. Green, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Okay. The complainant and the defendant have been married for 3 years. On November 17, 2024, officers were dispatched to a welfare check at a residence in Harris County, Texas, where the officers met with the complainant, who stated that the defendant and the complainant were having marriage issues due to the defendant cheating. The complainant stated that on November 17th, he observed the complainant laying on the couch, he observed the defendant laying on the couch talking to another man on the phone. An argument then ensued. The complainant stated the defendant grabbed a curtain rod and hit him twice on the leg while he was laying in bed. The complainant stated he called 911 because he was worried about safety and needed help. Just before the officers arrived, the defendant bit the complainant's left arm, causing pain. The officer observed the injury on the complainant's arm.
Do we know if he wants to have contact with her?
I'll read the RIP. A RIP was performed, so.
Okay.
Sorry, I missed the super chat. I apologize, Sloth Life. I'm so sorry.
Ms. Green, it looks like a protective order has been issued in this case. Get to know it. If you violate it, the state will file additional charges against you. A violation of protective order, it's one of the worst cases you can pick up. Until I know that he wants to have contact with you, I'm barring you from having any contact with this person. Do you understand?
Yes, sir. So it appears that the complainant does not want contact, and the complainant is moving out in order to make sure no contact.
Okay, do you have a child with this person?
No, sir.
Great. I don't want to talk about the case. It's
not about the case. The apartment that we have together is my apartment, but right now, since I got out, I've been at my grandma's.
So for now, right, this bars you from going to the Westmead place, right? So you need a lawyer to represent you in this case. You need a lawyer to represent you in this case, ma'am. Do you work?
I do work. I just started working. Whenever I was in court for
You get a lawyer for the magistration.
I didn't talk to anyone.
Okay. So what kind of money do you make a month?
Nothing right now.
How do you support yourself? Okay. Did you want to apply for a court-appointed lawyer, ma'am?
Yes.
The other option is you can go hire one. What would you like? Okay. Actually, I have one. So I have an affidavit already filled out. So what we'll do is I'll have you just sign a reset with Victoria. I'll have you sign here the order for protection, and then we'll have you take a seat. Don't leave until you sign our additional bond conditions, and then we'll have you talk to the lawyer here momentarily.
Okay.
Okay. Please.
It was already signed, Judge.
She says
Oh, that's right. Okay.
He
Yeah,
was
we just need to sign the reset and then we'll have
him.
All right, Judge, next is page 13 and 14. Maple, come on up.
You are on green bond.
Yeah, I'm gonna contact no weapon.
Yes, Judge, please.
Hat in hand. Is this a motorcycle driver? Just get your hat off the. Yeah. Let's see if he's a motorcyclist.
All right. Mr. Maple, I'm going to have you take your seat in the juror box while we wait for your lawyer. Take your seat for me over there, please.
Next is page 14. Nelson, come on up.
Mr. Maple has a lawyer already. Find yourself a comfy jury chair. It's Friday and it's a crazy day.
Same thing. I'm going to have him wait. I mean, we're going to have you wait. Your case is extremely old. We're going to wait for your lawyer to get here to figure out what we're going to do. Take a seat for me in the jury box, sir.
All right, Judge, next is page 15.
I need a second jury box.
We'll get some lawyers here.
Put them on top.
Stack them deep.
Start going back to the second row.
Come on up, sir. Vic, what was last name?
Page 15, Pearson.
Got it. Jaquan Peterson. Mr. Peterson, you're charged with reckless driving. You're facing up to 30 days and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On November 14th, 2024, the officer was part of a task force with the main focus being hostile street takeovers and racers. A large group of motor vehicles were meeting at the 11700 East Freeway in a parking lot in Harris County, Texas, when the officer observed the defendant's motor vehicle enter an area of the parking lot and begin to spin to this.
Si tú hablas, te pongo en la cárcel.
Don't talk. Hostile street takeovers, another bingo. Let's see, I think he was doing donuts.
Okay, sorry, please.
Would you like to start from the beginning, Judge?
Please.
Yes, Judge. On November 14, 2024, the officer was part of a task force with the main focus being hostile street takeovers and racers. A large group of motor vehicles were meeting at the 11700 East Freeway in a parking lot when the officer observed the defendant's motor vehicle enter an area of the parking lot and begin to spin his rear tires with a loud screeching noise. The defendant's motor vehicle did several donuts, losing control of the rear end within 10 to 15 feet of other motor vehicles making up the pit. The officer observed the defendant's motor vehicle complete approximately 2 to 3 donuts, and a traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant, and the defendant admitting to doing donuts.
Run his NCIC. Does he have any other cases like this by chance?
I'll run his NCIC, Your Honor.
Please. Mr. Pearson, I'm going to find that there's probable cause to go forward with your case. Can you imagine if you start doing these donuts, you hit and kill someone? Who gets charged with murder?
Caldwell?
These are things you must consider when you're out there in the free world. You think before you act, think before you speak, because actions may be your last.
And Your Honor, he has no other open cases or criminal history.
Do you have a Texas driver license?
Sir.
Do you have liability insurance in your name?
Sir.
Can you run this license, please?
Your Honor.
I'm ordering you as a condition of your bond not to participate in activities like this again. No reckless driving, donuts, street takeovers, racing. If I find that you do, the first thing I'm going to do is take your privilege to drive away from you, and the next thing I will do is I will put you in jail. Do you understand?
Yes, sir.
610. The freeways, toll roads, parking lots. This isn't the right way to put. You don't do this over there. And I'm going to tell you now, the Texas legislature has made it extremely easy for DAs across Texas to seize and take cars for individuals who participate in these types of actions. And I've had defendants come here with their cars seized, $50,000 trucks taken because of these types of actions. So
what kind of car do you have?
Be careful out there, because not only can you next time go to jail, but you may lose that very car that you had.
Guessing it's a Camaro. I'll just put it out there. I think he's a Camaro guy. Stock Camaro.
Can you file those conditions, please? No donuts, reckless driving, etc.
No
We're going to
donuts.
reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. After that, we will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. When you come back, please have a lawyer, sir.
Krispy Kremes is out. No donuts for you.
Potter, page 16.
Robert Potter.
Ooh, almost didn't see him
Mr.
there.
Potter, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you can afford one, one will be appointed to you, sir.
Yes, Judge. On November 17th, 2024, at 1:10 a.m. in the morning, officers conducted a traffic stop on the defendant's motor vehicle after observing it traveling at a high rate of speed, 67 miles per hour in a 45 mile per hour zone. Upon contact, the officer observed the defendant to be the driver and sole occupant and observed him with slurred speech, strong odor of an alcoholic beverage, and bloodshot, glassy eyes. The defendant admitted to drinking and scored himself as a 5 on a 1 to 10 intoxication scale. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 2 out of 4. The officer observed the defendant to be disoriented, drowsy, had slow and sluggish reactions, was uncoordinated, unsteady, as well as disoriented during the tests. An inventory search of the defendant's vehicle revealed a 12-pack of 12-ounce Modelo's in the back seat, as well as a 6-pack of 14-ounce Michelob Ultra with 1 container left. The DICs were read and the defendant consented to breath, the results being .097 and .099.
Is there any evidence that he's consuming while he's driving?
No, Your Honor.
Mr. Potter, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license? Do you have valid liability insurance?
Yes, sir.
In your name?
Yes, sir.
Are you sure? Can you run his license, please? Any prior DWIs?
No, Your Honor.
I'm ordering you as a condition of your bond, Mr. Potter, not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, unprescribed controlled medication, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
How old are you, sir?
19.
What do you do for a living?
Gold maker. Or never found.
How much money do you make a month? We're going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. I'll get you with Felicia for your bond conditions. And after that, you'll be free to go. Be careful. Don't use. I don't care what your excuse is. If I find that you're using, there's a one-way trip. You understand?
Yes, sir.
Okay, man. Come on.
Was he ordered to have an interlock?
Next is Simmons Irving, page 17.
Morning, Judge.
Hi, Louise. How are you? Ms. Simmons Irving, good morning, ma'am.
Good morning.
Ma'am, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer will be appointed to represent you, ma'am.
You forgot that part.
On November 14th, 2024, officers were dispatched to a trespasser call at a business in Harris County, Texas. The officers made contact with a witness who stated the defendant was asked to leave the business but was refusing to leave. The officer walked over to the defendant and tried to inform her that if she refused to leave, she would be considered trespassing. The defendant would not listen and did not want to leave. The officer attempted to detain the defendant and place her in handcuffs, but the defendant kept pulling away, refusing to give the officer her hands. The defendant also braced her legs on the ground to prevent the officer from removing her, and the officer had to use a reasonable amount of force to place the defendant in handcuffs and remove her. The defendant braced her legs against the seat and door and prevented the officer from properly detaining her in the marked unit. And once in the unit, the defendant grabbed and pulled the officer's shirt, trying to pull herself out of the unit.
She cut her earbuds in. Just listen to some
Okay.
tunes.
What store is this that she was in?
I have the address. I'll look to see if they have a store name listed.
Your Honor, ma'am, if I may speak.
Now's not the time. I mean, I've got a bunch of DAs here. Anything that you say, they're going to use it against you to prove guilt. You'll get the opportunity, I promise. Just now's not that time. How old are you, ma'am?
I'm 30 years old.
What do you do for a living?
I don't have a job. I'm disabled.
What's the nature of your disability?
I got cardioweb, a hematoma, deteriorating spine, hole in my heart, pulled over ligaments, bilateral kidneys, asthma, cancer.
How do you support yourself?
Currently at this moment, I'm supposed to be receiving, I got my Social Security claim number, but they refused to give me my award letter. And also, I was currently supposed to be residing at Vermilion Apartments, and my contract, I guess, was switched.
I want to know about the case. I just want to know how do you eat? How do you get money?
I don't.
I need you to fill out an application for me, and then I'll take a look to see if you qualify. As a condition of your bond, don't go back to this place.
You know, it appears to be a housing facility.
Okay. Do not go back to this place, ma'am.
So I can't go back to Houston Housing Authority.
Whatever this place where they were trying to trespass you from, don't go back, ma'am. I'll provide you a lawyer today, and we'll talk about how we go forward, but I don't want it to be more bad blood, and I don't want you to go back to jail. If you go back, they don't want you there.
That's police brutality.
There's got to be some other reasonable way that we can work things out, and we'll try. But you got to give it time, let things cool down. If you go right back after this issue now, you're begging for trouble.
Well, my contract is supposed to be terminated on 11/30, meaning I still have an active contract. So what am I supposed to be doing about that in regards to that? I mean, I have my paperwork to prove it.
I can't give you legal advice, but we'll have you talk to a lawyer and figure out how we go forward. Okay. For the time being, don't go back though.
Okay.
Please, because it's only begging for bad blood. Okay. Yeah, so I need you to fill out an application for me. I'll have you sign a receipt of Victoria, and then we'll just have you take a seat while we find your lawyer. Okay? Please.
Torres, Samuel, Ochoa Gonzalez, page
She has
19.
all the disabilities.
File, don't go back.
Yes, Judge.
Please.
She has all of them.
Which Gonzalez?
Ochoa.
Joe?
Sir, what is your name?
Torres, come on up. Page 19.
You were Samuel Torres. Mr. Torres, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine.
Let's hear what it is.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. Okay. On November 14, 2024, the officers observed the defendant's motor vehicle make a wide right turn at an intersection with a dividing concrete median, accelerate at a high rate of speed from the intersection, failed to maintain a single lane, moving halfway into the center lane before returning to the outside lane, cross over a solid white line into a bike lane before returning to the lane, and the officer observed other cars in the area at the time, rendering the failure to maintain a single lane dangerous to the other motor vehicles. The defendant's motor vehicle stopped at a red light and remained stopped after the light turned green, obstructing traffic, and the officer then initiated a traffic stop once the defendant's motor vehicle finally proceeded through the intersection. The officers had to travel approximately 0.5 miles from the original location as the defendant continued to drive. The officer made contact with the defendant, the driver, and the officer observed bloodshot eyes, an odor of an alcoholic beverage, and the defendant stated he did not immediately pull over because he lives at the apartment complex where the traffic stop was eventually performed and did not want his vehicle towed. The defendant stated he was coming from his sister's house, and the officer observed the defendant using the motor vehicle to regain balance. The defendant stated he had one Long Island liquor drink that he was currently consuming inside the motor vehicle, and the officer found a frozen daiquiri still frozen and half consumed on the passenger side of the floorboard.
He's drinking while driving?
Yes, Judge. And the officers performed standard field sobriety test, HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to breath. The results were .151 and .160.
Mr. Torres, do you have a Texas driver license?
Yes, sir, I do.
I'm now taking away your privilege to drive. You are not allowed to drive at all for any reason. And I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing up to 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand? Yes, from now on, you'll be taking the Dodge Patas. This is an affidavit that you're going to be signing with me today, promising me. And I don't care what your excuse is. If there's a burning building with 50 kittens you have to save, you get into a car and drive, we will have issues. I'm also ordering you not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail. You will not get any more PR bonds, sir.
How'd you get here today?
Any priority to be honest, Alex? How old are you, sir?
What
do you do for a living?
I'm a mechanic.
How much money do you make a month?
About 24 right now.
Who do you live with?
My wife, my sister, my daughter.
You might qualify for court appointed. Judge is doing the math.
Who else in the house works?
Just me.
Apply for an appointed lawyer, sir. So help me. Any issue, Mr. Torres, if I set your bond $5,000 to $10,000 and you ain't got anyone to pony up that kind of money, you will be stuck like Chuck until this case is over with. Make wise decisions while you're out there, because if you don't, I'm going to keep you. Do you understand?
Yes, sir.
Okay. Do you mind giving me an application, please? will have your application for an appointed lawyer. I need you to fill out everything. Don't just put zeros because I'm going to send it right back to you. I'll have you sign a reset with Victoria. You're going to have to meet with Felicia for your bond conditions. Then we'll have you take a seat in the jury box.
You're going to have to sit on somebody's lap in the jury box because it's full.
Page 20.
So many DUIs, so many reckless driving charges.
Do you speak English, sir?
Flores José Antonio.
Acérquese aquí al centro. Solamente mire el juez y le contesta con respeto en español.
Claro que sí. Florencio Martinez Vasquez Guillermo.
Sí. Guillermo, yes. Solo mire el juez.
Charged with driving while intoxicated.
Solo mire el juez, por favor.
You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one, sir.
Para usted, si usted no puede pagar por su propio. Solo quédese mirando el juez, por favor.
On November 17th, 2024, the officer conducted a traffic stop after observing the defendant's motor vehicle run a red light. Upon contact with the defendant, who was the driver and sole occupant of the vehicle, the officer observed the defendant with bloodshot eyes and a moderate odor of an alcoholic beverage. The defendant admitted to drinking and advised that he was coming from a party. Standard field sobriety tests were performed. HGN, 6 out of 6. Walk and turn, 5 out of 8. One leg stand, 2 out of 4. Inventory search of the vehicle reveals 1 open 12-ounce bottle of Modelo.
Drinking while driving?
DICs were read, and the defendant consented to correct. The results being 0.122 and 0.126.
Mr. Vasquez Guillermo, I'm going to find that there's probable cause. Tell me, are you a United States citizen? Are you in this country with or without permission?
No, sin permiso. No, without permission.
What happens if you go to jail?
Si usted va a una cárcel. Acérquese, señor, y no me mire, por favor, solo al juez. ¿Qué pasa si usted va a una cárcel?
No, pues, no sé.
Well, I don't know.
Are you in this country with or without permission?
Sin permiso.
O sea, entré con permiso, me quedé.
I entered with permission, but I stayed, I remained.
If you go to jail and immigration finds you, Mr. Vasquez, they will put a detainer on you and you will be stuck in custody until this case is over with. And then you will be shipped off to immigration where you will sit for another 6 to 9 months waiting for immigration to do whatever they're going to do. I would hope that you recognize it's elementary that you're not to have alcohol in the car while you're driving. And it is a minimum of 5 days in jail to any sentence you get if they allege the open container. I will tell you now that immigration sweeps it every single day. So if you spend more than 6 hours in custody, you will be stuck like Chuck with an immigration detainer. I am now putting conditions on your bond. And if I find that you violate these conditions, you will go to jail in a moment's notice. And I don't care if you're kicking and screaming. Do you understand?
Sí, señor o no, señor?
Sí, entiendo.
You are not allowed to drive. And you will be signing with me today a promise that you're not going to drive. I don't care what your excuse is. If I find that you drive, to jail you will go. Likewise, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you test positive for alcohol or drugs, likewise, you will go into jail.
De igual manera va a ir a una cárcel. That's fine, that's fine.
Any priority to be eyes?
No, Your Honor.
This is a pet peeve of the judge, his DUIs, and he comes
We're
down.
going to reset your case to give you time to hire a lawyer. So I will have you come up here, swear to us that you're not going to drive. This is an affidavit. I'm going to tell you now, Mr. Vasquez, look at me.
Míreme.
This is the only warning you will get from me. One violation whatsoever. I'm going to keep you with me. Do you understand?
¿Entendió eso, señor?
Sí, señor.
Yes, sir.
Okay. Coming up here, swear to us that you're not to drive. We'll get you to Victoria, and then we'll get you with Felicia for your bond condition.
All right, Judge, next is page 22, White.
Let's see what's this one.
Good morning, Miss White. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed
This
to you.
is in
ma'am.
Texas.
Yes, Judge. The complainant and the defendant are married. On November 16th, the officer was dispatched to a residence in Harris County, Texas, in reference to an assault. The officer met with the complainant, who stated the defendant and him had a verbal altercation that began the night prior, due to the defendant thinking the complainant was talking to another woman on the phone. The complainant stated he tried to sleep, but the defendant wouldn't stop arguing. The complainant stated that he slept in a separate bedroom, but the defendant came into the bedroom at 5 a.m. and started yelling at him, accusing him of cheating. The complainant stated he tried to walk out when the defendant struck him with a closed fist right between his eyes, causing him to feel pain and discomfort. The complainant stated he feared for his life and had no other choice but to call 911.
Okay, Ms. White, I'm going to find that there's probable cause to go forward with the case. Do we know if he wants to have contact with her?
Let me see if a request has been done, Your Honor.
Please.
No request has been done, Your Honor.
Okay. I don't know if he wants to have contact with you, so until I know, I'm ordering you not to have contact with this person. A protective order has been issued in this case. I would suggest you get to know it, because if you violate the protective order, the state can and will file additional charges against you, a violation of a protective order, and it's one of the worst cases that you can pick up. Do you understand, man? So you're not to have contact with this person and not to be in possession of any weapons. Do you work, ma'am?
I do.
What do you do for a living?
I'm school bus driver.
A school bus
What
driver.
kind of money do you make a month?
$8,000 a month.
Okay, we're going to reset your case to give you time to hire a lawyer. I'll have you go to Victoria, sign a reset. After that, we'll just have you take a seat in the jury box, so we'll get your bond commenced, you'll have you sign it, and then you'll be free to go in. Okay? Please. So no contact, no weapons. Please.
I think it was $3,000 a month.
Judge, that was the last.
We had one that had picked up another DWI.
Yes.
Uh-oh.
Where is your client?
He was sitting in the ERD because his prior case was ERD. He thought it was there. He's here now.
Okay. Can you bring him up, please? You speak English?
Yes, sir. Azel Gracia.
Okay, so this client has picked up another DWI. This is where he might come down hard on him.
No. It was DWIs.
Oh, that must be.
Yeah.
Page 12.
Yeah. What's the word with him?
So he checked in, counsel's not here.
Can you bring him up and put him in the, I don't want to lose him. Please. Joshua Jones, come up. Is there space?
I've got a spam call. Can we hold on for just a second? Hello? Hello? Hang on, I have to take my headset off. I can't hear you. Hello? Okay, I can hear you now. Sorry, what did you say?
Yes, this is Dwayne Bourne.
Yes.
Yes, my name is Malik, and I am calling from the fulfillment department here at Your Choice Getaways. How are you today, sir?
I'm doing well.
That is good to know. So I have good news for you. What it's showing me here looks like insurance was applied to a vacation package you bought a few years ago. And
Yes.
because of that, I am obligated to replace everything with our 2024 VIP package. And as a gift, we are including 4 round-trip airline tickets. Please grab a pen and paper so I can go over what you have.
Okay, hang on one second.
Okay.
Okay, I'm using an iPad. Is that okay? I'll try just type it out on that.
Completely understandable.
Okay. All right, I'm ready.
Okay, so there are 2 factors that I do have to cover briefly before I start with the destinations, and that is 1, the package is good for a lifetime, so if it takes you 6 months or even 10 years to travel, you can. 2, the package is fully transferable to a family member, loved one, or friend at no additional cost. Okay?
Hang on.
So
I'm a
first
slow
you
typer.
have
Just
a-
1 second.
Okay.
You said it was a lifetime for 6 months.
Good for a lifetime. Even if you travel takes you 6 months to travel or 10 years, you can. In other words, the package has a lifetime warranty.
I could travel for the rest of my life?
On the package, I mean, you could travel once. I'm saying the value, like.
Oh,
once
I
you
thought it was
travel on the package,
like a lifetime cruise. I'm like, that would
like
be pretty good. Do you guys have one of those?
I wish.
No?
I wish. I mean, if you become a member of the vacation club, sir, that is possible. But who lives for a lifetime?
Yeah.
Just saying.
Okay. All right. So
Just saying.
6 months to a lifetime. You
Oh.
said, I don't know why I'd want to give
Mhm.
this to anybody else, but I could transfer it if I wanted to.
Okay, so let me be a little more technical and put some clarity on that. So say for instance you have a particular destination that you're not fond of,
Mm-hmm.
and you're like, okay, I don't even want to swap it out for another destination. I want to just give that to a family member or a friend that really likes Vegas.
Mm-hmm.
You could actually swap out that individual destination and transfer that to a
I
loved
just
one,
like give
family
them the
member,
airline
friend, or-
ticket and they just fly with my ID or something.
Technically, I don't know how it works. Like my superiors,
But they could.
they know how it works.
That makes sense.
Yeah. Okay. So moving forward, it's fully transferable to a family member, loved one, or friend at no additional cost. Okay.
Okay.
So first, you have a 5 days, 4 night stay in Vegas with the option to stay on or off the strip.
I like Vegas.
Oh, you
but
don't?
I have.
You don't like Vegas?
I like Vegas, but I have a warrant out for my arrest in Vegas, and I
Okay.
can't go there.
Completely understandable.
Or else I get to stay in Vegas
Okay.
longer than I want to. And it's like 6 months to a year is what I'm facing if they get me. But so far they haven't extradited me from anything. So
Completely
could I swap
understandable.
Vegas out for something else?
Correct. You also have Branson, Missouri, Cocoa Beach, Florida, Clearwater Beach, Florida.
Cocoa
St.
Beach, Florida is
Petersburg,
also
Florida.
a no-no. I've got one there as well. But what was the Missouri one? I
Okay.
haven't been to Missouri.
Okay. Spectacular. So you can get a 5 days, 4 night stay in Missouri, Branson, Missouri.
Branson. Check that out. Okay.
Correct. Moving forward, next you have a 5 days, 4 night stay in Orlando, Florida. So you gotta keep one of the host destinations though, just to be clear.
Okay.
If you don't wanna do, the Florida, you can always let somebody who's qualified do the Florida.
Sheriff Grady down there has my name and number like on his wall. So I'd probably give
To
Florida
be
as
honest,
well.
I'm not even familiar with the polices or the in Florida.
Oh man,
But,
they're terrible. They'll lock you up for the.
No, I'm not saying. No, I'm
I
not.
was doing like
I'm in
120
Florida.
and a 70.
Pardon me, sir. Hear me out. I'm in Florida, and I'm not really familiar with that because I don't go to jail or like stuff
Well,
like
I
that.
only go to
That's
jail
all
if they
I'm
can catch me, and I just like to drive
okay.
fast, and so I don't know. They
saying.
have a problem with that.
I don't. It might sound weird, but I don't even have a license. But moving forward.
Do you drive fast, or you just don't get caught?
I don't drive at all. I just told you I don't have a license. sir.
like Uber. So you have to get a
Yes,
fast
I
Uber
Uber.
driver then. Okay, that's cool.
I'm not doing criminalistic endeavors. Why would I need a fast Uber
But
driver? Let's
speeding isn't
get away
really a
from
crime,
my
though, right?
Yeah, I mean, yeah. unless I'm getting away from my crazy girl. That's the only time I need a fast Uber.
Yeah.
When she gets insecure. But moving forward, you also have a 5 days, 4 night stay in Orlando, Florida, where you will be located 15 minutes from all the major theme parks. And this entails Disney, Universal, etc. Okay.
Okay.
Now, you also have an 8 days, 7 night all inclusive cruise with the options of Norwegian, Carnival, or Royal Caribbean. And this comes with 2 round trip airline tickets. In other words, airfare. Okay.
8 days,
Now,
7 night with airfare?
Yes, 8 days, 7 night, all inclusive with airfare. The options are Carnival,
Drinks, all you
Royal
can
Caribbean.
eat, everything?
Correct.
Do you know what, if they allow like multiple carry-ons, or is like you're only allowed one bag?
In that regard, I can't answer you. My superiors, they're gonna come on the line and any technical questions.
Put down a question for him later.
Oh, okay. Respectfully, I appreciate that, Mr. Bourne, because I'm relatively new here. Moving forward, you also have a 3 days, 2 night mini vacation in any major city of your choice, and this also comes with 2 round trip airline tickets as well as a car rental.
I've got one question on that one.
Go ahead.
Can you swap and make it a 3-night, 2-day? Because I'm more of a nocturnal person, and I'd be like losing like a third of the time that I would be up.
You think understandable? When my superiors get on the line, they'll be able to, customize the package to your liking.
Awesome.
Okay.
That sounds great.
Now, the only thing you are responsible for here today, Mr. Bourne, is your initial booking and processing fees. That was originally $5.99 for Traveler 1, $5.99 for Traveler 2. Your third and fourth travelers come at no additional cost. However, you are listed here as a preferred traveler, so this simply means you qualify for something special. Could you please stay on the line to let me see what that is?
Okay.
Okay, just give me 1 second. Just bear with me 1 second, okay? All right.
Hello, good morning. My name's Mark. I'm the account director here with Your Choice Getaways. How are you doing today, sir?
Hey, Mark. Good.
Hey, all right, excellent. Well, it's just my job to come on the line, further assist you, let you know about an additional trip you have here, answer any questions you may have, and see what I could do about those booking fees for you.
Okay. An additional trip?
Yeah, it's just a bonus trip, part of our holiday promotion we have going on here today. So it would be an 8-day, 7-night worldwide condo stay. And that's a fully furnished condo, good for over 2,000 resort properties around the world, including the United States, Canada, Mexico, the Caribbean, Europe, Central and South America, and Australia.
They're like, it has everything in it? Like the fridge is
Well-
stocked and everything?
Well, I don't think the fridge is stocked, but it's a fully furnished condo, so the fridge wouldn't be stocked, but comes with your living room, kitchen, 2 bedrooms, everything like that.
The TV and all?
TV and all.
Do you know if they have like cable, or do I have to like provide my own service?
No, they would have cable for you.
Okay. You said 8 days, 7 nights?
8 days, 7 nights.
And like anywhere in the world?
Correct. Besides the combat zone.
What are those exclusions? I do like going to like weird places, but like does like have to be like active bombing in the area and you can't go there, or
Right.
But like all the Middle East is just out.
Pretty much.
Oh. Okay.
So you'd have 5 trips, 4 round-trip airline tickets, a 3-day car rental. Now, the only thing you're responsible for here today is the one-time booking and processing fee. But like I said, we do have a holiday promotion going on here today. Originally it was $5.99 for traveler 1 and $5.99 for traveler 2. Your 3rd and 4th travelers are covered at no additional cost. So, with the holiday promotion, we could waive the cost of the 2nd traveler and get you paid in full for just $5.99.
Cool. So 2nd, 3rd, and 4th would be waived?
Yeah, so it'd just be $5.99. Your trips are good for up to 4 travelers. The only trip that's good for 2 is your cruise.
Okay. Is it possible to just bring person 2, 3, and 4 and leave number 1 home? So I could not have the $5.99?
Well, no, you'd be responsible for the booking fee here today, no matter what. Even if you leave the first person out of it, you'd still have to pay the booking and processing fee.
Okay. So it doesn't matter if that person would be 1, 2, 3, or 4, but I have to pay for one of them.
Yeah. So, are you interested in this thing or what?
It sounds awesome. It sounds great.
All right. So for the $5.99, we could take Visa, MasterCard, American Express, or Discover.
Can you use the card on file for that?
We don't keep cards on file, sir.
Yesterday I paid for the travel voucher credit from you guys.
We don't have that on file with us. It must have been a different company.
No way. It was $5.99 for that. I paid for, it was a lifetime of travel voucher credit insurance. It sounded like.
No, we don't do that.
Are you sure? Man.
Yeah.
Did I just?
All
did
right,
they rip
sir.
me off?
You have a good day.
Wait.
You have a
One
good
question.
day,
One
sir.
question for you. Do you mind if I use this on YouTube, because you're live with about 1,000 people listening right now? I think that he doesn't mind. He doesn't mind. Are you interested in this thing or what? What's the combat zone? That was new. I never knew we can't go to war zones, but everything else is on the table. That's the furthest I think we've ever gotten with one of those scams. My free trip would only cost me $599 to book. And then once I try to actually get the trip to happen, I'll find out that there are more restrictions that I can't take the trip that I want. Oh my goodness. Good stuff. Good stuff. All right. Judge Fleischer is waiting, and we're going to return to him. So.
You are Azel Gracia.
Sure.
Mr. Gracia, so
He's charged with, I've never seen this before, Judge, but he's charged with violating a bond condition.
yeah, I mean, I've certainly seen it.
And,
It's either
It's not a protective order, it's a bond condition.
right because they can't make the protective order case because it's been more than 61 days,
Had
right?
nothing to do with the protective order, Judge.
So yeah, right, I get it.
It was a different situation completely. Had nothing to do with family violence.
Get there. So you're charged with violation of a bond condition / protective order. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. If you cannot afford a lawyer will be appointed to represent you. So before we start, was he in a PTI? Is that why this case is 1,000 days old?
Yes, sir. He just has a few BIP classes left to finish the PTI.
Okay. Okay, go for
it. The officer was dispatched to a business in Harris County, Texas in response to a disturbance. Upon arrival, the officer observed the defendant grab another male aggressively, and the officer conducted a search on the defendant's person and found a loaded gun in the front pocket. The defendant is currently on bond for an assault family violence and has bond conditions in place prohibiting from possessing a firearm.
Yeah, all right. Mr. Gracia, I'm going to find that there's probable cause to go forward on the bond conditions. State, what's your position as far as he's in a PTI? He's now picked up a new case. Mr. Gracia, I want you to know that we take these bond conditions extremely serious.
Sure.
You don't, though. This is not your first VPO. This is not your first violation of bond condition. You don't get it. No means no. Doesn't mean maybe. Doesn't mean I'm going to a high crime area. No means no. And now there are consequences. Stephen.
Judge, can I tell you a little bit about the case?
Sure.
You know, just to explain to you what happened. He was at his business. He owns a trucking company. He hired somebody who he said he took a chance on him because he's has a sketchy record, convicted felon. It didn't work out within a couple of days, so he ended up firing the individual. The individual refused to leave the premises or refused to accept it. So he started threatening him. He went inside. The individual started trying to damage the trucks. So at that point, he was fearful. He went and retrieved a firearm that he knew was hidden in the vehicle. I'm sorry, in there. I understand, Judge.
It's about the worst thing that you can do. Imagine if you used a firearm. Who gets charged with murder, Mr. Gracia? Who has now dug themselves into a potential 50-year hole? We have a case like that today where a meager argument, someone who's charged with assault is now charged with murder because of a silly-ass, stupid-ass argument. Now, dude is sitting in custody with a $250,000.
And he's been punished at this point, Judge. He's been punished for violating the bond by getting an entire new case on that. So as far as him going into custody for violating the bond condition, I would hope that you would take that into consideration, the fact that he has gotten punished on the bond violation already, and the fact that he's already had to hire a new attorney for two cases at this point, and it's probably going to affect the other case. So I would hope that you would continue supervision on that, just taking that into consideration.
I truly appreciate your position, but you have an assault from 2019 of a family member. The following year, you pick up a violation of a protective order or bond condition. Now you have another assault that they were even, what the hell you're looking over there? Was it Jesus over there? You already have an assault of a family member that was dismissed as it is. You were lucky enough to even have this kind of an agreement where they're willing to dismiss a second assault of a family member. And now you pick up another violation of a bond condition. Eric, he doesn't get it.
I understand.
You don't get it. And now I have to show you, we mean business. I think that you are utter and complete danger to public safety. And I will do everything in my power to protect my public in every single way. Because the last thing I want is you to pick up a murder case like we have here this morning. Someone else goes with you.
Judge, one more thing. There's a bond condition on there that he's not allowed to return to that address. That address is his business. It's his place of business. The other person has no right to that address. So he hasn't worked for the last week and a half because there's a bond condition, I'm assuming from the magistrate, that doesn't allow him to go back to that business.
Show me proof.
I'd like to be able to take
proof.
that.
And you know, the proper, you know, and you need advice, the proper way to do things is you call the cops. Really. I mean, that's, if you own the business, you show it. I mean, how easy would it have been to just call police?
I mean, he has a right to defend his property and
not while the case is open. He does, but not in that manner.
It's one of those things where things happen quick and you have to make a decision. And when we're talking about trucks that are worth hundreds of thousands of dollars and things like that.
911, man. Really?
How long did it take to get there, Judge? So
okay. They will still take his ass to jail and then, you know, try to get restitution or whatnot. But
so as far as the bond goes, can you set him a bond today? So
of course.
And Judge, we've contacted Conrad because it's his case, but I just want to confirm that bond has been revoked for his prior case. Is that correct?
Yeah. Okay. Yeah. On the assault, I'm revoking it.
Yes, Judge.
Looks like they set the bond at $20,000 on the new case.
Yes, Judge.
I'm in America.
Because he's already posted that bond. He's already hired me. He hired me on the other case as well. There's a motion to sub in your queue that I need you to sign as well.
I'll sign it for you.
I'd ask that you set that new bond at $500. It's tough for the family, Judge.
He's not getting $500.
At this point, he hasn't worked in 2 weeks. He's trying to get back on his feet. He did everything properly. He didn't go back to the location because of the bond condition.
I'm not doing $500. I mean, I was thinking that was going to mirror the same one. I was going to put it at 20,000.
And that would be his state's position to mirror.
So he understands that we mean business. You know, if he's unable to bond out, I'm always willing to talk after a couple of days. You know, but I want him to understand that we take it absolutely serious. And when you go over there with a gun with the intent to do some serious damage, hell no, no way, no. And I think that making it 20,000, what the other one is, hopefully it'll get his attention. But like I said, look,
10,000.
Like I'm not out for blood, Eric. You know, so if he's unable to, after some time, come back, and I'm not talking weeks, but you know, a couple of days, so he realizes that we mean business.
Holiday. So we're talking about 2 weeks minimum. So would you consider doing 10,000?
Well, remember, I Zoom. So you can be in Abu Dhabi. I'm still here.
I can't be in Abu Dhabi. That's a war zone.
For sure. Okay.
It's a combat zone.
20 G's.
20 G's, 20 grand, 20 bands.
Anna.
We have a case we're going to be going to that Josh told us about.
Was that 20,000 units?
20,001.
20,001. We want that murder trial, and I think does anyone know if the murder trial's come up yet? Because we're a little bit behind on Judge Fleischer.
I'm here on Emma Lynch. She's got a bond violation. You wanted to talk to her.
Okay, do you mind bringing her up?
Yes, Ms. Lynch. When we were here last time, he ordered her to have the interlock installed on her vehicle. She is not driving the vehicle. It's not drivable. We just need to switch her to a portable.
Oh, no.
And a no driver.
She has nothing. And it doesn't matter. We ordered you to have an interlock in a car. You haven't done anything, and you're without any kind of devices whatsoever, right?
That was totaled, and it's at my house right now. But I don't have I'm in a rental car that I'm not driving, so I don't have a car to put it in.
So you have no device.
That's correct.
You're not being monitored.
That's correct.
This is not a good thing, Ms. Lynch, because I ordered you to have a device. And from what I understand here, you never even went and got it.
Because she doesn't have a vehicle to put it on.
But you come back and you say, hey, Judge, I don't have a vehicle. I need to do something else. You just don't, out of sight, out of mind. That's not the way things work.
Judge, for that violation as well, we instructed her in court and sent a message for her to report to 49 following court to get further instruction over everything so that we could figure out things from there, and she never reported.
Stephen, Ms. Lynch, you haven't done anything. They've literally bent over backwards to help you and do stuff, and you haven't done anything.
I wanted to come in today.
The only reason you're here today is because I ordered you here
Yes,
today.
sir. Yes, sir.
She goes with you.
Yes, sir.
Emailed, texted, call, nothing. you know.
I understand. Would you consider setting her a new bond or do you?
Of course. How about 1,001? And then, you know, if she's unable to, then what's today, Friday, Monday, then we can talk. Okay?
It makes me stop.
Yes, ma'am.
Yes, sir. Off your head, and you check in, come over here. Sir, you do not need to be talking to anyone in the jury box.
Yeah, don't.
Hey, hi, come on up.
Judge, Ms. Holly Harvey. Judge, this is DWI PTI intervention. Ms. Harvey's been removed from the program. Harvey, yes, Judge.
I'm bringing him up.
Ms. Harvey.
Good morning, Mr. Horn. It's been a while.
Around the other way.
I was hoping you'd give me some good news.
Here we are, Judge.
Shh. Everybody, you've been shushed by the judge. Please be quiet.
What did she pick up? Don't.
No.
Stephen, do you have room back there?
Yeah.
I don't know what to tell you, ma'am. You picked up a new case while you're on bond. We have one thing that we do when people pick up new cases, right? I have to revoke her bond. Sorry, ma'am. She goes with you.
Judge, if we could talk bond right now.
Sure.
Judge, we'd ask for a $500 bond. Judge, this is, she was on the program for, it looks like about 8 months. I don't know if there were any other violations. I just been on this case for 24 hours.
This audio is terrible.
But I know the new law violations triggering what we're triggering. But I believe he was in compliance on the DWI program.
Okay, I'm going to rest your ears for a little bit.
Compliance up to this new law violation.
We're resting your ears for just a little bit. I want to go back and watch the case he's got, the murder case. I want to see that. So if you guys can keep an eye out for that when it happens, let me know. But Josh has let us know about a little trial that has flown under the radar this week, in the last week, that I don't think anybody has seen. And it starts with jury selection on camera, or at least recorded. So give me just a second to get this accessed and pulled up here. All right, we're going to start right here. Just 1 second here. This is Zoom Court, but we have pretty good pictures and a pretty good audio as well. So let's jump in with jury selection and see how this goes. This is going to be a short thing. I think we can get through the entire case today.
All right, ladies and gentlemen, I appreciate your patience. You are here today for cause number CR 21-98, State of Texas versus Reginald Young II. Before I introduce the attorneys, I want to introduce my court reporter, Mrs. Azel Gracia, who's sitting before you. She is taking down everything that is spoken in the courtroom today. So if you will help me make her job easier, when you respond loudly, clearly, so she can make out what you're saying. Respond one at a time. Don't talk over one another. Don't talk over the attorneys. Just imagine being in her chair, trying to write down what everyone's saying at the same time. And if everyone starts talking at one time, well, let's just put it this way. You all get to leave. I have to stay here with her, okay? And I want her happy, right? She's the happiest when we're talking one at a time and it makes her job easier, okay? So at this time, I also want to introduce to you your attorneys representing the state of Texas and the Van Zandt County Criminal District Attorney's Office. Your elected district attorney, Ms. Taana Green. Assisting her today are her assistant criminal district attorneys, Mr. Chris Hartwell, Mr. Alfredo Hernandez. Does anyone on the panel know Ms. Curry, Mr. Hartwell, or Mr. Hernandez? If you can, just raise your paddle, raise your number so I know who you are. Raise them up higher. So jurors number 18 and 57. Juror number 18, who do you know? Ms. Curry. And juror number 57, who do you know? All three of them. All right.
All three of them.
And
He's
juror
out.
number 57, how do you know all three of them? Through work? Okay.
He's out.
And juror number 18, juror number 57, your knowledge of these individuals, do you believe it will in any way interfere with your ability to sit as a juror if you were to be selected and render a fair and just verdict based solely on the evidence? Juror number 18? Juror number 57? Thank you, sir. I appreciate it. All right. The attorney representing Mr. Young in this matter is Mr. Bill Stevens. Does anyone know Mr. Stevens? Mr. Stevens maintains a law practice over in Henderson and Kaufman County. Does anyone know Mr. Stevens? Does anyone know Mr. Stevens' son, Mr. Brad Stevens? And for the record, okay, juror number 44, do you know Mr. Bill Stevens or Mr. Brad Stevens? Brad Stevens. Were you aware that Mr. Bill Stevens was Brad Stevens' father? No. Okay, all right, then I'm not going to ask you any questions about that. Juror number 52? You know his son? All right, so you two individuals, do you believe that your knowledge of Mr. Brad Stevens will in any way prevent you from sitting as a juror should you be selected and rendering a fair and just verdict based solely on the evidence and not based on any knowledge you have about Mr. Stevens or his son, Brad Stevens, who is also an attorney? All right, thank you very much. Thank you, Mr. Stevens. All right, and the defendant in this case is Reginald Young II. Mr. Young, if you wouldn't mind please standing, sir. Does anyone know Mr. Young? And for the record, the court finds no numbers raised. Thank you, Mr. Young. All right, Mr. Young has been charged with the third-degree felony offense of prohibited weapon. And it is estimated that the trial in this case will take, as I mentioned to you earlier, we're thinking no more than a couple of days. We should hopefully finish on Wednesday by the close of business around 5 p.m. That is contingent upon how long the jury deliberates, something that I have no control over. So we could possibly go into Thursday. So just want to kind of give you that as a time frame. As the jury panel today, you have been seated in the order in which your names were selected using a purely random process. This is done purposely so that no one can manipulate who may sit as a juror on any particular case. During jury selection, it is important that you let us know certain things about yourself because the attorneys will have a very short time during which to get to know you. I'm going to allow each side 45 minutes to conduct their examination of you. During that examination, some of the questions that you are asked may feel to be somewhat personal to you about how you feel about certain things or life experiences or perspectives. I promise you no one is trying to embarrass you in any way or pry unreasonably into your private life. The purpose is to determine if any of you may be influenced by your personal beliefs or knowledge in such a way that you could not serve as fair and impartial jurors in a particular case. You must listen closely to the questions from the court and the attorneys and respond fully and honestly. Your failure to do so could result in a mistrial and all of our time will have been wasted. When you do respond to a question, please raise your juror number. During jury selection, some of you will be eliminated for legal reasons. After that, each side will have 10 what we call peremptory strikes, which may be exercised for any lawful reason. A peremptory strike removes a name from the list of potential jurors. After the eliminations for legal reasons and peremptory strikes, the first 12 names remaining in the order in which you have been seated will form the jury in this case. The verdict of a jury in a criminal case must be unanimous. That is, all jurors must agree. The trial of a criminal case in Texas proceeds in 2 phases. In the first phase, the jury is called upon to hear the evidence and decide only whether the defendant is guilty or not guilty. This is oftentimes referred to as the guilt phase of trial. Only if the jury finds the defendant guilty does the trial proceed to the second phase, also known as the punishment phase. And in the second phase of trial, the defendant is entitled to choose whether punishment will be assessed by the judge or the jury. In this case, the defendant has elected to have the jury decide punishment should he be found guilty. When we do begin the trial itself, the prosecution will begin by opening statements. The defense will also have an opportunity to give an opening statement. The prosecution will then offer its evidence through witnesses whom the defense may then cross-examine. When the state is finished with their evidence, the defense may or may not present a defense because the defendant is never required to prove his innocence. If the defense does choose to put on witnesses, then of course the prosecution will have a fair opportunity to cross-examine them. At the end of all of the evidence, I will give the jury a written explanation of all of the law that is applicable to the case, along with instructions for the jury on how to reach its verdict through deliberations. If in deliberation the jury reaches a not guilty verdict, then the case is over. If the jury reaches a guilty verdict, then we will proceed to the second phase or the punishment phase of trial. And the procedure for the punishment phase mirrors that of the guilt phase or the first phase. It is the function of the jury in this trial to determine the facts. In doing so, you are the sole and exclusive judge of the credibility of the witnesses and the way to be given their testimony. Even I, as the judge, am not permitted to influence your evaluation through words or actions during the trial. My job is to decide the law and to be certain that both sides receive a fair trial. Evidence consists of testimony, which is generally direct evidence of what someone saw or heard, and also exhibits. You may draw reasonable inferences from the evidence. What the attorneys say is not evidence, their questions are not evidence, and their arguments are not evidence. All witnesses should be evaluated equally. Just because a witness is a law enforcement officer or a pastor or a teacher or some other occupation, you must evaluate all equally. Evaluate whether they appear to be telling the truth and whether their testimony is consistent with what they have said, or if it's consistent or inconsistent with other evidence in the case. You may also evaluate their appearance, attitude, and behavior using your common sense. A few of the general legal principles that I think it would be helpful for you to know. Oftentimes we will talk about a case having elements. Those are the individual requirements for a crime that the state must prove. For example, an element is that the crime occurred here in Van Zandt County, that it occurred on or about a certain date, that the accused person on trial is the person who has committed the offense, and other particular things to specific offenses. Each of those is termed an element, and the state must prove all elements for a conviction. The burden of proof in this case and in all criminal cases rests solely on the state of Texas throughout the trial. Never at any time does it shift to the defendant. The state must prove every element of the offense beyond a reasonable doubt. The defendant is presumed to be innocent unless guilt is established by legal evidence received before you in the trial of this case beyond a reasonable doubt. If after you retire to deliberate, each of you believes beyond a reasonable doubt that the defendant is guilty of the offense charged or of a lesser offense permitted under the instructions given to you, it will be your duty to return a verdict of guilty. If you have a reasonable doubt as to the guilt of the defendant, it will be your duty to return a verdict of not guilty. However, the state is not required to prove its case beyond all possible doubt. Any accused person in any criminal case is not required to prove himself or herself innocent. If the defendant chooses not to testify, you may not consider that fact as evidence of guilt, nor may you in your deliberations comment or in any way allude to that fact. The indictment in this case is also not an indication of the guilt of the defendant. It is simply the legal means by which a person in Texas is brought to trial for a felony. The fact that a defendant has been arrested, confined, or indicted for, or otherwise charged with an offense does not infer guilt at trial. The defendant in this case, the prosecution, the public, and our system of justice all require that a fair jury, one without bias or prejudice and free of opinion as to guilt or innocence of the defendant, be chosen here today. A fair jury is one that, not having heard any of the evidence, is not already committed to either side. A fair jury is one that is impartial to both sides and that can and will follow the law as given to it by the court. Put another way, an impartial jury is defined as one which does not favor a party or an individual because of the emotions of the human mind, heart, or affections. It means that the defendant, the case, and the issues involved in the case must not be prejudiced. Everyone has biases. Please be honest with yourself and the attorneys about any bias you might have one way or the other that may affect your ability to be fair and impartial in this case. Just because you have a bias in one direction or another does not necessarily disqualify you from serving as a juror. You may have a bias that you can set aside in order to. Everyone has biases. Please be honest with yourself and the attorneys about any bias you might have one way or the other that may affect a possible $10,000 fine.
Judge, we're not going to get done in 45 minutes if it's like this. What does a jury do? Listen, very good. That's the first thing a jury does.
I have to back up here what she said just a second ago.
We're going to have to go through this process. Somebody who's been on.
Okay.
Nobody? I usually get one or two.
Come on, I missed it again. Okay, here we go. There we go. Very beginning of what she says.
Good morning.
Good morning.
Yeah, that's about a C plus.
Yeah.
All right, I'll let it slide. I'll let it slide. I'm going to start off by apologizing to y'all for my voice and for the fact that I have a cough drop in my mouth. I'm not eating candy, I promise. But last week at this time, I couldn't talk at all. So we're doing better, okay? Just one of those fall colds that a lot of us get. Who wants to be on a jury today? Nobody? I usually get one or two. All right, who's been on a jury before? It was that bad?
Everybody that's been on one before.
So since I didn't get 12 volunteers, I guess we're going to have to go through this process. Somebody who's been on a jury before, tell me what a jury does. If you were paying attention, the judge just told you, but he kind of told you in some legal terms that he's required to use. What does a jury do? Oh, boy. Judge, we're not going to get done in 45 minutes if it's like this. What does a jury do? Listen, very good. That's the first thing a jury does. Listen to the evidence, right? What else does a jury do? What if the evidence doesn't agree? What if some says it's blue and some say it's red? What does the jury do? They decide who's telling the truth, right? Judge told you the jury is the judge of the credibility of the witnesses. That's fancy words for the jury decides who's telling the truth, right? Okay, what else does a jury do? They return a verdict. What's that verdict based on? Evidence. Very good. And only the evidence, right? And what the judge told you just a few minutes ago was what the lawyers say is not evidence. The evidence will come to you from the witness stand, sworn testimony, from exhibits that are admitted into court. They might be videos, pictures, recordings, physical items, anything. That is the evidence. What else does a jury rely on? The law. The law, right? Now, any lawyers out there? I didn't think so because I didn't recognize any of you as being lawyers. So what are you going to do for the law? At the end of the trial, if you're selected on this jury, the judge will give you the law in writing. That is the law that governs this case. And that is the only law that you need for this case. Okay? It'll be everything you need. So those jurors who are selected on this case are supposed to make their decision. They'll take an oath to make their decision only on the evidence they hear and only on the law that the judge gives them. Not what they might think the law is, not what some other law might possibly be, not what the law of somewhere else is. That law and that evidence. Okay? So now, what's this process about? This process is to find people who can do that. Or basically, as the judge told you, to eliminate or deselect people who can't do that for some reason. What's one of the great things about America? There's no thought police. We are free to think whatever we want, right? We can think a law is stupid if we want to. But in here, if you're selected to sit on a jury, whether you agree with that law or don't agree with that law, you'll take an oath to uphold it, right? Personally, I do not like the seatbelt law. When you're as short as I am, that seatbelt comes about right across here, and it makes your neck itch, and it just is a pain. I don't like it, and I'll be honest with you. Maybe if it's a short trip, I might not use it because I don't like it, okay? But if I were on a jury, and the allegation was that a person violated that seatbelt law, as much as I didn't like that law, I would have to take an oath to enforce it, and I can do that. I don't have a fundamental disagreement with it. I just don't like it. So I can take an oath to enforce that law. One of the things we're going to do this morning while I'm visiting with you is see if any of you have such a fundamental opinion about certain laws that you couldn't enforce them, right? And if you don't, that's fine.
She's attacking juror
But if you do
nullification first thing.
have that type of opinion about the law that you can't enforce it, that's fine. Having an opinion, not being able to enforce the law yourself, that's not a crime. We'll say thank you for coming and responding to your service, but you won't be selected for this jury. All right? Now, let's get down to fairness. The judge said we're looking for fair jurors. So my question to you is, who is unfair? I got one. Very good. Very good. Actually, in reality, most of us are unfair about some things, right? We have been inundated for the last, I don't know how many weeks by political advertisements. I am so sick of hearing them. Some of them I can recite from memory. I've heard so many times. Who has an opinion as to whether all political advertisements are true? Who thinks all political advertisements are absolutely true? Who thinks all political advertisements are not absolutely true? Some are untrue. Yeah, if you've seen the same ones I have, some of them are untrue, right? So if this were a trial about political advertisements and truthfulness, those of you who just raised your card, could you be fair? No, you already have an opinion, right? I bet a lot of you have already voted for president. You've already made up your mind. If this trial were about who should be president, you already have an opinion, right?
Josh, tell me we
So
don't go
you
down
would
this road.
not be a fair juror. That's all we're looking for, is people who could make the decision as the law requires only on the evidence and the law that the judge gives. People who do not already have their minds made up. Okay? So that's what my questions are going to be about today. Do you already have your mind made up about something that's relevant to this trial? And if you do, hey, that's not a problem. You'll get to go home. Okay? So let's get started then. I'm going to follow up a little bit on what the judge said about the burden of proof. What's the burden of proof in a criminal trial in our country? Come on, I know you've heard it on TV. What is it? Beyond a reasonable doubt. I'm going to go back to something that I usually say and I didn't have written down this time. The judge told you, I told you that jury selection is really deselection. If you have one of those opinions, then you're probably going to be eliminated as one of the 12 people who serves on this jury, right? How are we going to know if you have one of those opinions? What'd you say, man? Asking questions, and you have to answer the question. That's right. You know who winds up on a jury? The 12 people that wind up on a jury are usually the 12 people that were the quietest out here. Because we have to presume that you don't have an answer to our questions, And therefore, you don't have one of those preconceived opinions that would make you unfair for this trial.
She's trying to get him to talk.
So everybody's been pretty quiet so far. And
Ayden,
everybody told me they
congratulations
don't
on
want to be
Bitcoin.
on a jury. Not even one of y'all wants to be on a jury. So I would suggest we start talking. All right? What's the burden of proof in a criminal trial?
Beyond reasonable doubt.
Beyond a reasonable doubt. How many Law and Order, FBI, all those kind of shows fans do I have?
Just a couple.
Yeah, y'all should have known that. Beyond a reasonable doubt. Now, it's very irritating to me when I watch those shows that sometimes they get it wrong. A lot of times they get it wrong. Beyond all doubt, beyond the shadows of a doubt, beyond any doubt, beyond this, beyond that. Our Constitution says beyond a reasonable doubt. Why? The judge already told you the state does not have to prove it beyond all doubt. Can I ever prove to you something beyond all doubt? Only if you saw it yourself, right? Guess what? If you saw it yourself, are you going to be in the jury box? You're going to be on the witness stand, right? Okay, that's why it's not beyond all doubt. Now, criminal trials, that's a high burden of proof, and it should be. It should be, because what's at stake in a criminal trial? Sorry? Someone's freedom, right? Beyond a reasonable doubt is actually the highest burden that we have in our justice system, whether it's civil or criminal. But it's not a burden that we're afraid of. It's a burden that we welcome, that we think is just and fair. And it's a burden that we're going to ask that you tell us that you can hold us to, but also that you not hold us to beyond all doubt. Why is that? It's not possible. That's right. It's not possible for us to prove to you something beyond all doubt unless you saw it yourself. Right? So who says, you know, Taana, I understand that criminal trials are serious. The judge has told us that this is, if this man is found guilty, it's a 2-year to 20-year in prison case. I just can't work with beyond a reasonable doubt. You would have to prove it to me beyond all doubt before I could convict a person and consider sending them to prison. Anybody? So the reverse must be true. You can work with beyond a reasonable doubt. Right? Now, the weird thing, the weird isn't a good legal word, but the odd thing is that our legislature does not give us a definition of a reasonable doubt. Each juror gets to decide that individually for themselves. Okay? Everybody okay with that? Anybody have any questions about it? By the way, jury selection is the only time you get to ask us anything. So if you have a question, raise your card. But everybody here is telling me that they can work with the burden of proof beyond a reasonable doubt. And that if in fact the judge tells them that's the law, as he already has this morning, and I expect he will several more times, that that's the burden and only that burden that you will hold the state to. Everybody? Now, what do we have to prove beyond a reasonable doubt? We have to prove those elements that the judge talked about. Again, this part, jury selection, is not evidence, right? Because I'm talking, and that's not evidence. So I am not allowed to tell you the facts of this case because I don't get to testify. And I am not allowed to ask you then, what are you going to do in this case? Because you haven't heard any evidence, right? If the judge passed out verdict forms right now and said, guilty or not guilty, you'd have to check not guilty, right? You haven't heard any evidence. So I'm not allowed to go into that with you, but I can talk about what the elements of the offense are. And as Judge told you, the first element is that it was this specific defendant, Reginald Young II, on or about November 25th of 2020. Now, 2020, that's been a while back, right?
She gets
A lot of
45
things have
minutes.
happened since 2020 and now, right?
This can be like it.
One thing that you'll learn if you're selected on this jury is that we don't get to talk about why the offense was in 2020 and the trial is in 2024. But I can tell you it's not the fault of anyone in this court, okay? Anybody who says, I would have to know, I can't do it without, I can't sit on a jury without knowing why the offense is so long ago and we're just now having a trial. So everybody's telling me that's something you can absolutely put out of your mind if you're selected on this jury. My voice is not going to last very long, y'all. In Van Zandt County, Texas, the defendant intentionally or knowingly, what's that mean? I'm sorry? It's a culpable mistake. Basically, it means on purpose. And the judge at the end will give you written definitions when he gives those jury instructions of intentionally and knowingly. But basically, to sum it up, just means on purpose. Remember when you were a kid, got in trouble? You said, but I didn't do it on purpose. Right? Right? That's a phrase we all can work with. Intentionally or knowingly possess a short-barreled shotgun. I'm going to spend a lot of the rest of my time here talking about that particular element and the law that applies to that element, okay? Second Amendment of the United States Constitution, what's it say? Right of the people to keep and bear arms shall not be infringed, right? That amendment is very near and dear to me, as I'm sure it is to many, many of you. I spent 4 years on the women's U.S. pistol shooting team. I'm a hunter. I like firearms. They are fun. I believe that that is a right I was born with. Anybody agree? Absolutely. It's not a right that a government, federal government, state government gives to us. It's a right that we were born with.
We're in
It's one of
Texas.
the big things I like about living in the great state of Texas. Not all states, not all cities agree with that. The question we have to address in this Mordiah, and this is where we're getting down to those feelings and opinions about law and whether or not you agree or disagree with the law, and whether or not, even if you disagree with it, could you still enforce it? The question we have to deal with is, does the government have the right to limit that? Second Amendment. Who thinks yes? Everyone in the back? Who thinks no? So our law in the state of Texas and federal law says that a convicted felon surrenders their right to possess a firearm. In the state of Texas, 5 years after they finish their sentence, they can have one at home. Federal law does not have any exception. Federal law says you're a convicted felon, you can never possess a firearm again. Is there anyone who believes that the federal government or the state government, because of the Second Amendment, do not have the right to impose that restriction? If you hold your card up till I call your number, then you can put it down. Number 4, number 6, number 15, number 23. Next row. All right, number 44. Anyone else?
State what you said.
I'm sorry, sir?
State what you said about federal government. Right.
to impose a law that says a convicted felon cannot possess a firearm. Everybody hear me? Both our federal government and our state government have laws that say convicted felons cannot possess firearms. Is that right? There's anyone other than the numbers I called who don't believe that our governments have the right to impose that law. All right. Now, those whose numbers I called, if you were selected to sit on a jury where that law was being litigated, could you enforce it? 4, 6.
Hey, Ms. Curry, did she say I don't think so? Can you develop that, Ms. Curry, please?
Okay.
This was this week.
I'm going to have to ask him to give a definite answer. I don't think so. Doesn't like you said. You would not be able to. Okay. Number 15, would you be able to? Oh, I'm sorry. No? Okay. 23? 44. Thank you very much. Look at that. Nothing bad happened. Right? Sure. All right. Now, so we see that our governments have determined that they have the right to limit the Second Amendment in some instances with regard to a certain class of people, right? Now, our governments have also determined that they have the right to limit the Second Amendment based on certain classes of guns, right? Machine guns. Illegal to possess a machine gun. Short-barreled shotgun. Short-barreled rifle. Illegal to possess. Zip gun. Some other things. Illegal to possess. Even by a law-abiding citizen. Okay? Now, got the Second Amendment that says the right of the people to keep their arms shall not be infringed, right? But yet, the state of Texas and the federal government both say it's unlawful to possess a machine gun, it's unlawful to possess a short-barreled shotgun, it's unlawful to possess a short-barreled rifle. Who here thinks that the government does not have the right to impose that law? All right, again, if you'll leave your cards up until I call, that'd be great. 4,
This
6,
is the most Texas
7,
thing you're going to see in Texas,
8,
I think.
9, 15, 17, 23. Next row, anyone? Oh, I missed 19, sorry. 36. Over here again, 39, 44, 50, 51, 35. Did I miss you? Is your card up or down? Okay. 50, 51, 61, 64, and 65. Now, of those people, this trial is about that law. The allegation here is that the defendant violated Texas law by possessing a short-barreled shotgun. In other words, a shotgun with a length of barrel that
Less
was
than 18
less
inches.
than 18 inches. Those of you who just raised your card, or anyone else who didn't raise their card, who says, because of my beliefs in the Second Amendment, I cannot enforce that law.
Look at all these
And
people.
again, please keep your cards up
These are people who will
until
not
I
be
call
sitting
your
on the
number.
jury.
And ladies and gentlemen, let me remind you one more time. If you're selected to sit on this jury, you're going to take an oath to enforce that law. So if you can't take that oath and you can't follow that oath, now is the time to let us know. All right. So 4.
These are
6,
people who say I cannot
8,
enforce
15,
I cannot support the law
17,
that bans
23,
those sawed-off shotguns.
39, 44, 50, 51, 61, and 64.
Wow. A lot of people want the law changed, apparently. This is a bench trial. Or well, no, this is not a bench trial. This is a jury trial.
So that's not
That's why we
quite
have the jury
everybody
here.
who raised their card about disagreeing with it. The rest of you who disagree with it, it's kind of like the seatbelt law. You don't like it, but you can still enforce it. Correct? Yes, sir.
We deal strictly with a felony, a person that is a felon and owning and being able to possess those things.
No, sir.
Okay.
This is an ordinary, my question goes to
Because I was under the impression that you could have an automatic weapon if you had standing. You have permits.
federal law, yes.
And the length of the shotgun, I was under the impression was 16 inches, not 8.
Rifle is 16, shotgun is 8.
That's my issue with the question is clarification, making sure that everybody is fully aware of what the law says.
And for my question, an ordinary citizen, not a convicted felon, ordinary citizen. All right, is there anyone who would change your answer based on those clarifications? All right, wait, so 7, you could not enforce that law? 8, I already have you. 47 and 35, you could not enforce that law?
These are people that are not going to sit in on the jury.
Anybody else?
There's going to be no jury here.
Anybody here who's ever had any experience working on or repairing firearms? 7, 8, 34? Only with your husband?
All the people who said they can't support the
I'll
law.
pick on you a minute. If I took the barrel out of your handgun, how quickly could you put it back in? Minutes.
Seconds.
I'm sorry?
Seconds.
Seconds.
He's like, I'm quick.
What
Takes
about a
seconds.
firing pin? If I took a firing pin out of a weapon, very quickly. Again, seconds. Did everybody hear what he said? The rest of you who've worked on firearms, you, sir, I think you said you had. Do you disagree? If I took the barrel out of your pistol, how quickly could you put it back in? All right. What about a firing pin?
It would take
How
me under a
quickly could you
minute.
put it back in?
Firing pin's a little
Couple
harder.
minutes?
They're not going to be able to see the jury.
That prohibits possession of certain classes of guns, the law that prohibits felons from possessing any gun, does not require that the gun have all the parts. Can be missing a barrel, can be missing a slide,
Can be missing a
can be
barrel.
missing a fire pin, can be missing an ejector, an extractor. Doesn't even have to work. Why? Because you can make it work real quick. Real quick. Some of those parts you can pop back in, as juror number 3 said, in a matter of seconds, in a couple minutes. Doesn't make it any less dangerous if you can pop the part in a matter of seconds or minutes, right? Same goes for the law about short-barreled shotguns, short-barreled rifles, machine guns. It doesn't have to have all the parts. Doesn't have to operate. Is there anybody who says, well, Ms. Curry, now that you've told me that, if I were on jury, the gun would have to operate before I could convict someone. The gun would have to have all the parts before I could convict someone of possessing an illegal weapon like a machine gun or a short barrel gun. Anybody at all? All right, so I'm going to make you commit to this one, folks. If you're selected to sit on this jury and you take that oath to follow the law, and the law is that the firearm does not have to have all the parts, does not have to operate, and you believe everything has been proved beyond a reasonable doubt, raise your card if you can return a verdict of guilty. Well, that's not very many.
That's not a
I
jury.
must have asked a bad question.
It was.
If you're selected to sit on this jury, or any jury, where the offense alleged is possession of a prohibited weapon, that's what the law calls a machine gun, short-barreled rifle, a short-barreled shotgun, and you hear all the evidence, and you believe that the state has proved the defendant possessed that weapon on there about that date in that county, but the evidence showed that the firearm did not work, was missing a part, and you still return a verdict of guilty if the judge tells you that's what the law is.
Now we get a few hands. So I'm trying to talk to Mrs. RA into getting me some of the
Yes, I can
stuff
do.
she just bought at the grocery store. She's showing me like key lime
It might be
pie,
missing a part.
chips and dip.
It's in his possession.
Chocolate pie.
It might be missing a part that it would need in order to shoot a bullet. But you believe beyond a reasonable doubt he had it. Can you return a verdict of guilty? All right. Anybody who can't? Anybody who cannot?
7 won't. 7, 8, 17, 34.
Yeah,
I can't make your questions too big.
Okay. All right. Okay. Raise your card again if you need to know more or you have a question about that. All right. 4, 6, 15. I'm okay with y'all. 7, 8. I'm
You're
okay
gone
with
already.
you. 17. I'm okay with you. All right.
They're already gone.
Anybody else want to talk about that? Have any questions about that? All right. Texas defines a short-barreled shotgun as a shotgun with a barrel length of less than 18 inches. No reference to single shot, over and under, side by side, semi-auto, no reference to that. Everybody okay with that? Sure.
Is there any type of other stipulations along the street? Because they do make it. Hostile shot.
If you check it, it'll have a barrel length of right at 18 inches. There's a lot of snake charmers you can buy that have a barrel length right at 18 or 18 and a quarter.
This guy has one. And he's like, are you telling me my gun's illegal?
I bet you it has a rifle bullet. There's a shotgun that's fine as sweet of a rifle bullet would make it exception. Okay?
Just that make it a rifle or a shot.
Depends on what he's shooting, though.
The cartridge.
Depends on what caliber he can shoot. Designed for shotgun slugs, but with a rifle bore. Okay. Okay.
These guys are like, you're telling me my guns are illegal?
All right, we're going to turn the page and get off of that. Is there any more questions about it?
Only in Texas. This is awesome.
Yes, ma'am. Number 52. My question was about an ordinary person, right? All right, so let's talk briefly. Yes, ma'am. You're freezing to death, you too?
I know. This lake is freezing.
Who's not freezing to death? Who's not freezing to death? Sorry, ma'am. Sorry, ma'am. If I turn it off, everyone's going to get hot.
Yeah, keep your way.
I'm not in trouble.
This is the wildest
right.
jury selection. They're complaining about the temperature
Let's talk for just a
already.
minute about some of the witnesses we may call in this case. Obviously, Judge has already told you we represent the state of Texas. We're the ones bringing the charge. We bring a charge when law enforcement makes an arrest. So some of our witnesses in this case are going to be law enforcement officers. Is there anyone here who, and this goes back kind of to the fairness aspect of what Judge was saying. And if you paid attention, he said, preachers, law enforcement, all kinds of people, classifications, they should start out the same as any other witness. Now, in today's society, a lot of law enforcement are, let me back up. One bad apple tend to get the whole basket. And right? I think we would all agree that we've all heard news stories about some bad law enforcement officers who have done some things they shouldn't have done in the past few years, right? Does that mean all law enforcement officers are bad? Nope. Flip side, a lot of y'all probably have law enforcement in your family, maybe even yourself. You probably have a lot of respect for those people.
Defendant, like,
does that mean all law enforcement officers are good?
Go to the bathroom.
So is there anybody who says, because of my personal relationship with a law enforcement officer, or because of a personal experience I've had with a law enforcement officer, they're going to start out, when they take that witness stand, I already know their credibility is above or behind another witness? Anybody like that? All right, number 3, thank you, sir. Number 17.
They were already out.
Number 15, all right. Anyone else?
Let me just say, these are terrible answers.
Thank you very much.
If you want
now,
to be on
I'm
the
going to
jury.
make it, oh, yes, sir, number 38.
Another question.
I'm going to make it a little tougher. And I will tell you that one of the witnesses we expect to call is an ATF agent. Bureau of Alcohol, Tobacco, and Firearms. How long has it been? 20 years? 20, more than 20. They got a really bad rap. They made some mistakes, a few of them.
I've been interviewed
But
by the
the whole
BTF.
agency got a really bad rap on some things that transpired.
She's talking
Is
about
there
Waco,
anyone who
Texas.
says, because of that, or for any other reason, maybe you've had a personal dealing with ATF,
I have.
I just can't judge them the same, judge an ATF agent the same as I would another person who was called to testify? Anyone at all? Number 30? Number 52?
I have
Yes,
never
sir.
seen this type of question on this widespread of a uniform dissent in a jury pool before.
And I'll change my question. Good point. I'll change my question. Above or below? Would you judge them above or below an ordinary lay witness who was non-law enforcement? All right. 3, 15, 17, 6, 30, 56, and 38. All right. Anyone else? Anybody in here have an FFL, Federal Firearms License?
No.
Used to? Anybody who used to have one? All right.
Those are people that can own machine guns and sawed-off shotguns. And
Anyone
things like
else? All right, so let's go to my last area of questions here. Judge told you that when a criminal defendant is found guilty in the first part of the trial, the second part of the trial proceeds to punishment. And we have to talk about it now because it's the same jury that will do both, so we can't come back and do a different jury selection if there is a verdict of guilty. So I want to talk about the punishment range here. We've told you what the punishment, what the offense is, the elements of the offense. Now, our law says that that crime is ordinarily punished by between 2 years in prison and 10 years in prison. Okay? Again, I'm a lawyer. I'm not giving you evidence. So I cannot, it would be totally unfair of me to ask you, if this guy's found guilty, what punishment are you going to get? You don't know. That 2 years to 10 years is a big range. Why do we have big ranges? Some ranges in Texas are 5 years to 99 years. I'm sorry? Correct. We have ranges for two reasons. Not all criminal defendants are the same. Some of it might be the first time they did something. Some of it might be the 15th. Who knows? Not all offenses are the same, right? You could have somebody, the example I usually use is murder. Couple that's been married for 50 years. The wife has terminal cancer. She's suffering and suffering and suffering. And the husband can't take it back. So what's he do? He goes over and he pulls the plug on the machine that's keeping him alive. Intentionally or knowingly caused the death of another. He did. You might have a 10-time convicted felon walking down the street, escaped from prison, took a guard's gun, shot the first people he saw and took their car. Murder, right? Intentionally, knowingly took the life of another. Those two offenses deserve the same. Not at all. Not at all. That's why we have punishment ranges. And sitting here right now, you don't know anything about this case. You don't know if it's an egregious case. You don't know if it's an escapee who shot somebody in a car to steal their car. You don't know if it's a man who pulled the plug. You don't know if it's a person who's been convicted no times in the past, 10 times in the past, right? So I'm not asking you what you would do. I'm asking you if you can consider the whole range, right? Can you consider giving 2 for someone you found guilty of possessing a short-barreled shotgun? Yes. Anyone who cannot? Number 30 and number 6. All right.
Number 13.
And a lot of you who've already raised your cards on can't enforce that law, I understand. Okay. You couldn't enforce the law at all.
You're already out.
Anyone else besides those who say they can't enforce the law at all, who could not consider, just consider that there might be a circumstance where they would give 2 years for the crime of possessing a short-barreled shotgun? How about 10 years? Anyone who says there are no circumstances that I could even consider 10 years? Yes, ma'am. Number 4.
Number 36.
Saying, consider the 2 to 10 or the 2 to 3 not.
Could you consider giving 10 years, not knowing anything about the crime? It may be a really bad one. Not knowing anything about the person. He could have a long history.
Yeah.
Could you consider giving 10?
Yeah.
All right. Now, yes, sir? No? Okay. Now, let's throw in this fact. Our law says if the person convicted of this crime, possession of a short-barreled shotgun, has been convicted of a felony in the past and has gone to prison for that felony. In other words, it was serious enough that they didn't get probation. They actually went to prison.
For a year or more.
Then the punishment range becomes 2 years to 20 years. Okay? So under those circumstances, if that were proved to you beyond a reasonable doubt that the person had previously been to prison for a felony conviction, could you consider 20 years? Not knowing anything about how bad the offense is, not knowing right now whether that was the only conviction or whether they had more, could you consider 20 years? Anyone who says, I couldn't consider 20 years. All right, 46, I've got you. 52, I've got you. 47. Anyone else? 44. All right. I don't know how long I've been up here, but my voice isn't going to take much more, and I am out of cough drops. Y'all don't want to see me have one of the coughing fits I've been having lately.
It's time to sit down now.
So I'm going to wrap it up. But before I do, I want to ask one more thing. If you've been sitting out there thinking, oh, I bet one of those lawyers would want to know this, because it's really something that happened in my life that I can't put out of my mind. It would affect me if I were sitting on a jury where the offense charged was possession of a short-barreled shotgun.
It's a long thought.
Well, now's your chance. Or even if it's just anything not that specific, anything at all that you think we would want to know about you and your ability to be fair and impartial, your ability to decide this case only on the evidence and the law that comes from the judge. Anything at all, now's your chance. Great. And let me say this, ladies and gentlemen. If it's something really private, we can approach later and you can talk about it just in front of the lawyers and the judge. Okay? All right, so who has a response to that, what I call the catch-all question? Anyone? Number 30, I got you. Number 52, number 31.
She's got to be almost done here.
Anyone else? Number 31, is it something you'd rather approach the bench about, or is it something you don't mind talking about here? Okay, go ahead, sir.
You should know. It's a former detective, violent crimes.
Okay, for what agency?
In South Carolina.
In South Carolina. Thank
He's
you,
a
sir.
former detective of violent crimes in South Carolina. State's
Anyone
gonna want
else?
him.
Number 30, yes, sir. I think we've got you covered, sir. You're all right.
You're already off the jury, number 30.
I've got you covered. Anyone else? All right, ladies and gentlemen, thank you very much for your attention. And
wanna
we
see what
look
the
forward
defense
to
does
working
here.
with the 12 of you who are selected.
The new use exactly 45 minutes.
Oh, what do you know?
All right, ladies and gentlemen, it is approximately 11:30. I'm going to give you an option. And because this is America and this is the great state of Texas, we're going to vote on it. All right. Option number one, we recess for about an hour 15. We take a lunch break. You leave, you come back, and then we continue with Mr. Stevens and the defense jury selection. Or we take a 15-minute break. Everyone stretches their legs, uses the bathroom. We come back and we do another 45 minutes. And then it'll take the court about 30 minutes to pick the jury. And then you go home. Option one is lunch. Option two is go home earlier. Option one. Oh, for those of you who didn't see her, she wanted to vote for option one. And then when she didn't see you all vote for option one, she pulled it back down quickly. Maybe someone, option two? Yeah, there we go. I just want to make sure that they were going to vote. We're going to make sure they're going to vote. Maybe one of these other ones will take you down to the vending machine and buy you something. All right. So with that, we'll take a 15-minute break. I'm going to ask everyone to be back in your seat no later than 11:45. Ladies, if there's still a line for the bathroom, there's restrooms downstairs also in the basement. All right. There's a men's up here, women's right here. There's also men's and women's in the basement. Ladies, if there's still a line, then don't worry about it. We won't start without you. Okay. All right. When you exit the side and the back and re-enter, leave your numbers right there.
Okay, so we're going to skip the break really quickly. I don't think the judge says much.
It'll take as much time as a prosecutor did.
They cut it out already. Where's the jury?
All right.
They cut it out already for us.
All right. So with that, we'll take a 15-minute break. Here, women's right here. There's also men's and women's.
Okay, here we go. I thought I was going to have to skip it, but they trimmed it for us.
All right, Mr. Stevens. It's your crowd.
Just say I'm not going to yell at you, and you've got them all in your hand.
All right, ladies and gentlemen, I'm not going to take as much time as the prosecutor did because there's no point in me going over everything she did just to beat a dead horse, so to speak. But first of all, I want to tell y'all about myself, okay? I'm a former Dallas police officer. Formerly served in the United States Army back during the Vietnam era war. I have 2 kids. One of them works with me. He's an attorney. My other son, older son's in Dallas. He's a banker. I have 2 beautiful grandkids. So that's a little bit about me. And by the way, I live at Cedar Creek Lake. So originally from Dallas. But anyway, that's me. Just in case y'all want to know a little bit who I am and where I'm coming from. First of all, as the judge says, I want to thank each and every one of y'all also for being here. It's about the best thing you can do to serve your country other than the military, police officer, school teacher, things like that, that's serving our country. But I do appreciate each and every one of you being here because, you know, they don't do this in Russia. They don't do this in Afghanistan. They don't do trials like they do in the United States. And so I sincerely say that I appreciate each and every one of y'all taking time out of your schedules to be here because I know you've all got places and things you'd rather be doing than be here. But again, I do appreciate it. Ladies and gentlemen, I just want to kind of stress the point that during a criminal trial, what's called the burden of proof is on the state. It never shifts to the defense. All we have to do, ladies and gentlemen, is just show up. We don't have to put on any testimony. I don't have to call any witnesses. I don't even have to cross-examine the state witnesses if I choose not to. Now, it's not going to be that way, but I'm just trying to get the point over that all the defense has to do is just show up. It's completely up to the state to prove their case beyond all reasonable doubt. And that's what we're talking about in this case, ladies and gentlemen. It's going to be reasonable doubt in this case. You know, y'all are going to be the judge of the credibility of the witnesses. Y'all are going to be judging the evidence. The judge will give us the law. However, y'all will be the judge of the credibility of each and every witness. You know, y'all might believe something they say. You might believe everything they say, or you might believe nothing they say. It's completely up to you folks as to judge the credibility of the witnesses. Now, I know Ms. Curry asked y'all this a while ago. I'm going to ask it one more time, though.
I've got 4 so far from him.
Is there anybody here that would put a police officer's testimony on a higher level to begin with than any civilian witness that may testify? Yes, sir. You feel that way? In other words, anytime a police officer gets up, you're going to feel like that his testimony is going to be credible and more important than anybody else's? Okay. Okay. Yes, ma'am. Number 7. Tell me. Do you think, would you put a police officer's testimony up higher than anybody else's? Okay. Do you have a law enforcement in your family or? Okay. Where did he work? Oh, Dallas. Okay. Yes, sir. Number 8. Okay. Would you put their testimony ahead of somebody else as far as credibility goes? Okay. And I saw some other paddles go up. Yes, number 32, please. You would put a police officer's testimony up higher than anyone else's? Okay. Do you have a law enforcement in your family? Or you do? Okay. You said your husband? Okay. Is he a police officer? Okay. And 57, yes, sir. Okay. Do you have officers in your family or law enforcement? You are? Okay, sir.
Like,
where do you work?
I am a law enforcement officer.
In Van Zandt? Okay. Well, I noticed a while ago you knew everybody, so I figured it. Anybody else on this side of the room? How about this side of the room? Anybody felt like that they would start a police officer's testimony on a higher level than any civilian police officer? All right. Yes, sir. You'd start the police officer on a higher level of credibility than, okay. Do you have, may I ask, do you have law enforcement in your family or no? I'm sorry?
Cousin law enforcement? There are a lot of removed for cause potential jurors here.
What the state and I were both looking for, we're looking for 12 fair and impartial jurors, 12 people that will listen to the evidence, that will render a judgment based upon what the evidence shows. We don't want people that's going to get back there and not really pay any attention and just vote with the masses. We want people that will be hard-minded people. Look at the evidence, vote guilty or not guilty on your conscience. We don't want people back there pulling a straw or just voting with the masses.
So the lady who raised her hand for early lunch or for lunch and then stay later.
I've noticed on the
they don't
jury
want her.
Cards that some of the folks have been on civil juries before. Some have been on. Has anybody been on a criminal jury? Yes, ma'am. Did y'all, not to know what kind of case it is, did y'all reach a conclusion? You did? Okay. And yes, number 50.
Say,
Did y'all reach a conclusion on it? Okay. And 51?
you play out.
Okay. And I saw another, yes, sir, 37? Did y'all finish the case or went to jury? Okay. And 29? Did y'all finish the case? Did he go to the jury? Okay.
Got someone on the right side. We got 11.
Anybody on this side? Yes, sir. Number 11. Yes, sir. Did not. Okay. Number 34. Okay. 36. Went all the way through. Okay. And 46. All the way to conclusion. Okay. And 59. Okay, sir. All right. Thank y'all very much for that. Ladies and gentlemen, I'm going to leave y'all with that. I'm not going to sit here and keep talking. Again, I want to thank y'all for each and every one of you for being here. It's really important that y'all are here. And we hope to pick 12 people that will pay close attention and render a verdict according to the testimony and the evidence. Thank y'all very much.
All right. Fast forward.
Thank you.
All right, again, ladies and gentlemen, thank you for your patience. This time, Ms. Wilson is back, and we do have the jury that has been picked in this case. When you hear your names, please bring your personal belongings and come have a seat in the jury box. Ms. Wilson.
Elizabeth Dennis.
I guess I'm going to mute this for a minute. We don't need their names. The court doesn't have a problem providing the identities of these jurors. Literally, the court filmed this, edited this down, because it was originally happened on the 4th, edited it down, and then published it on the 5th, or 5 days ago. So this is a trial that happened on the 4th, as you can see in the date stamp in the corner, but they just posted it live 5 days ago. They're cool with these names getting out. They're cool with us seeing the jurors. Some courts do that.
Bradley Burleson.
Bradley made it. Congratulations, Bradley. Oh, way back in the back. So good mix of people up there. Some from both sides. Variety of ages.
All right, ladies and gentlemen, I'm going to have you all rise so I can administer the oath of the jury. So all raise your right hands. You and each of you do solemnly swear or affirm that in the case of the state of Texas versus Reginald Young II, you will a true verdict render according to the law and the evidence, so help you God. All right, thank you. You may be seated. All right, to the remainder of the panel, I want to again express my gratitude for your patriotism and being here today. I hope that you found the jury selection to be not so much entertaining, but informational and educational part. I learned some things about firearms today that I didn't know. So I hope that you can appreciate the purpose of what we're doing here today. And then when you go out and you tell other people that you were on jury duty, it wasn't about, oh, I got a summons for jury duty and it was so boring and I hated being there. But you can go back and tell them that this is a fundamental part of our criminal justice system and encourage them to answer their summons. Okay. For your appearance here today, you are entitled to $20. If you would like to donate any of that, all of it or any portion of that to one of the nonprofits that have been approved by the Van Zandt County Commissioners Court, you can see Ms. Wilson here as you leave. She can give you a form. You can redirect that. Otherwise, you're welcome just to go on home and we'll send a check to your address. Okay. So many people always ask me, Judge, why do you bring in 60 people or 100 people when you're only picking 12 or 13? And I tell them, obviously, we don't know who is going to be summoned at that time. And when they come, we don't know what their life experiences are going to be. We don't know what philosophies they have, perspectives they have. We don't know what law is perhaps going to be used in that case where someone might have an opinion on it. So it takes more of us to get down to the group that we need. And so I don't want you to think that because you weren't picked that your time wasn't wasted. And those of you that didn't get picked, you can quit smiling now. All right. They've already been picked. They've already been picked. Okay. So again, thank you for your time. Thank you for your attention. You are excused at this time.
I think we wrap up here. We're going to take a lunch break. We're going to come back, and I think we can follow both day. I think we can have both days of evidence, day 1 and day 2 this afternoon. So it'll take us to the weekend.
Mr. Stevens, Ms. Curry.
Come on up here. We're muted for a little sidebar. Waiting for the unfortunate ones to exit the building. Apparently nobody wants to hang around to just watch the trial. Got just a little bit to go here. Possibly opening statements.
All right, ladies and gentlemen of the jury, I want to give you just a few more instructions and then I'm going to send you home. Okay. We're not going to start the evidence today. This is what you can expect during the trial tomorrow. And there's a scheduling conflicts that we need to work around. So tomorrow we're not going to begin until 1 p.m. Okay. 1 p.m. So what you'll do is when you arrive to the courthouse, you'll come and in just a few moments when I'm through giving you these instructions, you'll go into the jury room with Deputy Martinez. He's going to get your contact information. We ask that you give us your 2 best contact numbers so that we can reach you in case there's inclement weather, water main break, something that could cause us to delay. We'd want to call you at home and keep you at home rather than bringing you up here. When you do report tomorrow, you're going to report to the jury room. You will not re-enter through the courtroom. Today, when you go in there, you'll exit out a back way. So you'll go in that same way because we may be doing things in here that you do not need to be privy to at the time. Okay. So we'll begin tomorrow at 1 p.m. And when we do, then we'll have the state present the indictment to the defendant. He'll enter his plea before you, after which then the state will have the opportunity to give their opening statement. Defense can then give their opening statement immediately thereafter, or the defense can wait until the close of all of the state's evidence, and then they can present their opening statement. It's an election that they get to make tomorrow. After which the state will have the opportunity to present its evidence first, state bearing the burden of proof in this case and not shifting to the defendant. They will call their witnesses first. They'll put on their evidence first. They will argue first. At the very end, they will argue last. Okay. They'll call their witnesses. I'll swear in each witness before you. The witness will then take the stand. We'll have direct examination by the state through questions. There may be objections by either the defense or the state. And if the court has to entertain an objection, you're not to speculate or worry about what the objection's for. I will deal with that and then we'll move forward. After the state has called all of their witnesses and marshaled all of their evidence, then the state will say in front of you that they rest their case. They admitted all of the evidence that they seek to in the case. After which then the defense will be given the opportunity to present a case if they so choose, remembering that there's a presumption of innocence. And that alone is enough to acquit the defendant. So the defense doesn't have to call any witnesses. They don't have to put on any evidence. But if they do, as I've already told you, then the state will have a chance to cross-examine their witnesses and their evidence, okay? And that process will continue until we've heard all of the evidence. Once we've heard all of the evidence, then I'm going to give you written jury instruction about what to do in the case, how to apply the law to the case, and then how to reach a verdict. So you don't have to go out and educate yourself on anything. You don't need to go. Matter of fact, I'm going to instruct you not to. Don't go get on Google. Don't Google any of the terms that you've heard today. Don't try to find out more about the defendant or the attorneys for the state or the attorney for the defendant. It's best that you do nothing other than show up, be attentive, and listen to the evidence, listen to the law, and then follow the law when you apply the evidence to reach your verdict. That's all you need to do, okay? We will give you a phone number so that you can give your loved ones, so that when you're in here, I'm not going to allow you to have your phones present with you in the courtroom. And as a matter of fact, when you go to deliberate, I'm not going to allow you to have your phone at all. At jury deliberations, we'll take your phone so that we know that there's strict confidentiality back there in the jury room. No one else will be present with you in the jury room, not a bailiff, not an attorney, no one. And so we'll keep the phones out here. So if there's an emergency, we'll have a phone number for your loved one or whoever needs to reach you to call. And then we can interrupt whatever's going on, whether we're at trial or jury deliberations, to get that message to. Okay, so that's why we ask for two numbers, okay? So we can reach you at home, and then we'll give you that phone number so that they can reach you while you're working, okay? We've already had a complaint about it being a little cool in here. I'm gonna keep it cooler than I am warmer. So bring a jacket, bring a sweater. If you need to bring a little blanket or something, that's fine, I'll do that. I do not allow food and drinks in here because it always tends to make a mess. So you are welcome to bring water. You can bring food and drink with you, and you can keep it in the jury room. Have no problem with it being in there. There's little cubbies in there where you can put your personal belongings, bring your food and your drink in there. Do I have any diabetics or anyone that has to regulate blood sugar? Do you? Okay. Do you have a monitor that you need to bring with you? No? Okay. If you do, that's fine. Just want to make an accommodation for that. But you're welcome to bring food and drink. Keep it back there. When we start, we'll probably go about an hour and a half before we have a break. All right. If something comes up and you need a break, just raise your hand. Let me know, and we'll break when we need to. Okay. Otherwise, we'll go about an hour and a half, and we'll take a 15, 20-minute break, and then we'll resume. So if we start tomorrow around 2, then around 3:30, start at 1, around 2:30, and we'll break. And then we'll try to finish every day as close to 5 as possible. On Wednesday, you're going to arrive at the courthouse no later than 8:45, be in the jury room, and we'll just get started at 9 a.m. We'll go 9 to about 10:30, take a break, and we'll work until noon, take a lunch break, and we'll come back about 1:15, 1:30, depends on where we're at. I'll try to stop us as close to 5 as possible. Do I have any daycare issues in here with any kiddos that need to be picked up at a certain time? No? Okay. We'll still try to stop as close to 5 as we can. Unless there's a witness or someone who's taking a little bit longer, we may want to finish that up before we continue. The attorneys are still confident that due to the number of witnesses and evidence in this case, that we're likely to be done by Wednesday, even starting tomorrow afternoon. So things may move quickly. And if they do, then I'm going to have some notebooks available for you tomorrow so you can take notes. You're welcome to do that. You're welcome not to either, just whatever, is your preference. So you can take notes, and that way you can refresh your recollection about what the testimony is. Then after you've received all of the evidence, you've received the court's instructions, then I'm going to give the attorneys for the state, the attorney for the defendant, the opportunity to give their final arguments. After that, then it's your job. It's your turn. I'll send you to the jury room, we'll deliberate, and we'll reach a verdict. All right, so let's see, parking. Probably the best place to park is either at the City of Canton parking over here underneath the water tower area, or over the Van Zandt County Courthouse Annex. That's public parking. We ask that you not park around the square because we do have commercial vendors, businesses here that are relying on those parking places. So don't park in any private parking lots, okay? So it's best to be at the courthouse annex on the other side of the mobile gas station on the south side of the cemetery, the first Monday over there. Also, when you come in, we're going to have plastic magnetic jury badges for you to put on, so that I ask that you wear those on the outermost part of your clothing, so that when you're walking around the courthouse, people will know who you are, what you're doing, number one. And number two, it allows the attorneys the benefit of knowing if they're working on their case outside in the hallway, they'll know not to say something within your presence that you don't need to hear. Everything that you hear in this case should be here in this courtroom, either under the rules of evidence or the rules of procedure. Okay. Alternate juror, sir, you are a part of the jury, but when it comes to deliberation, not even the law doesn't even allow you to be in there. So when the jury goes to deliberate, as long as none of these 12 are unable to fulfill their duty, then at the time they deliberate, you will be separated from them. Should one of them not be able to fulfill their duty and they're discharged from the jury, then and only then will I install you onto the panel for you to deliberate. But in the meantime, you will do everything else they do. So when they exit, you exit. When they enter, you'll be back there for all of the jury stuff except for deliberations, unless you're placed on the panel. Okay, and it's my policy to always have an alternate, even on short trials, because I've learned that lesson the hard way. And when I don't, if we have an emergency or someone gets ill and our jury becomes less than 12, then it creates other legal obstacles that the court has to overcome. So I just err on the side of being more cautious. Okay. Do you all have any questions at this time? Yes, ma'am.
Should we plan on trying to take Thursday off just in case, or is it pretty set in stone that will be done by Wednesday?
Nothing is set in stone, but I don't think you need to make arrangements for Thursday. In the event, the attorneys are very confident that we will hear all of the evidence by Wednesday. So if there's deliberation, we may deliberate into the evening. If it takes several hours, let's say that you don't get to start deliberating until 2 or 3 in the afternoon on Wednesday, you deliberate 4 or 5 hours. And what we'll do is we'll just stay here until your deliberations are over, which means it could be into Wednesday evening. I will do my best to avoid Thursday. Question? You've got this curious look on your face, line.
I just I'm part of you're safe with this.
Okay. Well, I guess you can always surprise them if you show up, and they won't be surprised if you're not there. But if you take off Thursday and we don't go Thursday, I won't answer my phone until next week. So you're on the honor system with your career. So those are good questions. Any other questions? Okay. Then let me give you some instructions here. During the case, no communication is going to be permitted. So you're going to be instructed that you're not to discuss this case with each other or anyone else. Okay. So that means first witness gets on the stand and they give their testimony and I call for a break. It'd be improper for you to go back and go, hey, what do y'all think about that testimony? Think that person's lying? Truth? What do you think about that evidence? You're not going to be permitted to discuss any of this until you receive all of the evidence, court's instructions, and the closing arguments. Then I will tell you, now's your time to deliberate. Then and only then will be your opportunity to discuss what you've heard in this case with each other. You're not to discuss it with anyone else. So you're not to go home
and we're all done.
Give a Facebook update or a YouTube update about what happened in court today. You're not to discuss this case with anyone else at all. Doing so would be a violation of your oath, and it would be jury misconduct. You could be held in contempt. So it's very important.
We could lock you up.
If anyone attempts to communicate with you about the case, your other jurors, anyone outside the jury, then I want you to report that to Deputy Martinez. He'll be the bailiff who has you in charge. You report that to him, and the court will deal with that. As I mentioned before, do not read newspapers, do not watch television, listen to, you can tell how old these things are, listen to radio reports. We need to ask some things. Don't go on social media or things like that, trying to learn more information about it, okay? No outside investigation is permitted. It is important that you pay attention, as testimony will not be repeated for the purpose of repeating it. Sometimes juries think that they can get back into the jury room and send out a note and say, hey, we would like to have all of that testimony read to us again. Well, you'll find out at the end of the case that it's not. The law doesn't allow that. The law allows for the jury to request that certain portions be read back only if it is in dispute, meaning that some of you have different recollections of what it is, and you need that to be clarified. But for purposes of just refreshing our recollection about what everyone said, it's not permitted. So it's very important that you pay attention. If you can't hear a person testifying, raise your hand, let me know. I'll be paying attention to that as will my staff. So I will make them speak into the microphone. If I need to turn the air off, I'll do everything to make it, to encourage them to make it to where you can hear and see everything. If we watch a video or photographs and you can't see, raise your hand and let us know. We won't know otherwise. Okay. You're reminded that the statements that you're going to hear by the attorneys, including their opening statements, closing arguments, their questions, are not evidence. The evidence will come from the witness stand and through exhibits. I've already discussed objections. Those are normal legal procedures by the attorneys. So when an objection is made, the court must rule on it. Don't conjecture, don't speculate, don't worry about what that is. I'll deal with the legal aspects. You'll deal with the factual aspects.
No
You're
questions.
the judge of the facts, credibility. I'll judge the legal issues, okay? I think that is it for the most part. Any other questions before we go? All right, so everyone try to be here by, say, 12:45 tomorrow. Deputy Martinez will give you more information about that. And then if you have any issues, he'll have a number for you to call. Just any issues arise in the morning, give us as much notice as you can. Give us a call, okay? All right, so one last thing. When you exit the courtroom and when you enter the courtroom, because you are the jury, we are all going to stand in your honor, okay? So that means you come in, you don't have to remain standing because you are the jury. We're standing for you. So you just come in and be seated. And the only assigned seats in here are the alternate. He's the only one that's got that seat over there. So if any of you need to move around, you don't have to wait for someone to get to a certain seat unless they told you they want that seat. Okay. So if those of you who are in the back row need to be in the front row, if it helps you, then, make an accommodation for that. Let people know, be the first one out the door, but these are not assigned seats. Okay.
We're in Canton, Texas.
The jury.
There goes the jury.
Will step into the jury room, Deputy Martinez.
We're in Canton, Texas. We're going to be back right after lunch. All this trial should fit nicely, and I mean quite neatly, into this afternoon. Both day 1 and day 2. Let me just double check here. Yeah, we've got... It's going to be a full day. We've got under 4 hours of video. 3 hours and 40 minutes. We'll give you this whole trial. So we'll get the whole thing. We'll get the whole thing right before the weekend. So there's going to be no, I wonder what happens on Monday. No, we're going to be starting fresh on Monday with new stuff. So we are in Canton, Texas. We'll be back here in a little bit. Jury has been seated. A day 2 trial. This is a possession of unlawful weapon by a restricted person, I think, charge. We'll go into that a little bit more later as well. But I need about half an hour. That brings us back about 1:15 Eastern time. It's 12:45 right now. Half an hour for me to run out and get some of this yummy food that Mrs. R.A. just ate. I'll see if I can raid the kitchen. I know it's all supposed to be for Thanksgiving, but some of it needs to be tested now. So I will be testing that as soon as I can. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again in about 30 minutes. Have a quick lunch. We'll see you back here in a bit. I'll make a portal for us. But I'll do it quietly. See you in a minute. Still making the portal. You'll be ready in a moment. Don't go anywhere. Your device is not broken. Please remain seated. Keep your hands and feet inside the ride at all times. Okay, new one is up. Create the link. Add. Save.